May I be permitted?
Yes.
Yesterday, Lordship, release of my matter. Yesterday I mentioned, Your Lordship, release of my matter for want of determination. Your Lordship has determination, let it appear tomorrow to be mentioned. Your Lordship has determination.
If I release, then how you can keep
on the ground of Your Lordship's not determination.
No, I already passed an order for release.
Yes, release, as Your Lordship has no determination.
Yes.
But it is a listed mention, Your Lordship has determination, irrespective of classification. Therefore, it is Your Lordship.
If I pass the order, unless and until the order is not recalled, how this court can
let
take?
it appear tomorrow to be mentioned, Your Lordship, kindly see whether it.
Once released, how it is to be mentioned? You have to take appropriate steps, either recalling of the order or to reassign the matter by the Chief Justice, Secretariat of the Chief Justice.
Already
option.
By mistake, Your Lordship's order is by mistake.
Correct. You have two options. Either you file a recalling of the order or you reassign the matter. This is the two options. Yes, sir.
I was just mentioning this matter, that blacklisting of contractor. It is appearing today as item number 34.
Yes.
Now, Milord, this interim order will be expiring on day after tomorrow.
Okay.
Now, this was the last order, Milord.
Okay, let it be remain in the list.
Yes, I also intimated the other side.
If day after, if it is not come tomorrow in the top or whatever it is,
Yes,
then
Milord, if your Lordship kindly, Milord, gives that accommodation.
I will take.
So that I can, Milord, because your Lordship heard it and the other side is also, Milord, saying that I have no objection.
I will take.
May I have your Lordship's leave to mention item number 73, my Lord. This was filed pursuant to leave obtained from your Honor, my Lord. It was taken up on the 13th and the respondent took time for obtaining instructions, my Lord. And after that, it has come up today as item number 73, my Lord. My Lord had directed it to come in the top 10 matters. I'm making a very innocuous prayer that a tender is there, my Lord. I only want consideration of that tender in terms of the CIL and the Director General of Mine Safety Regulation, my Lord. That is it, my Lord.
So what
can I be permitted to mention?
The
order sheet, the visa of the petitioner is sorry.
Which chamber you belongs?
What?
Which chamber you belongs?
Lordship, my senior is Mrs.
Who is your senior?
Kakuli Nashkar.
You learn this only?
No, Your Lordship.
Yes, my Lord. I'm only praying for consideration of the tender. If my Lord sees the last order, it was filed after obtaining
item number
73 of your Lordship's list, my Lord. PVR, my Lord.
Okay, let us see.
Your Worship,
Yes.
under compelling circumstances, may be permitted to mention a SIR matter. The predicament is my caste certificate is not getting verified, Your Lordship. I have completed for the SLST 2025 procedure. If my Lord could kindly accommodate me in this.
I don't know. I will take. If the file is traceable, then it will be listed. If file is not traceable, I don't know. Because thousands of files are there of the SIR. I will take your mentioning, but if my court officer able to find out the file, it will be listed. Take that.
Your Lordship, may I be permitted?
Yes.
Your Lordship, in the order sheet, it is recorded that the petitioner passport has got expired, but the petitioner's passport has got expired, but in reality, it's the visa that of the petitioner has expired, and he is facing difficulty.
Correction, to be mentioned, correction.
May I be permitted to mention a matter, Milord?
Urgency I'm mentioning, the petitioner is a NEET aspirant. Her counseling process has begun. Only because of domicile certificate has been denied, she is not being able to participate. Although her SIR process is also cleared. Although her SIR process is also cleared. She is being denied just because her mother's...
SIR process also cleared means what? You got
her
the
list is, I mean, her name is appearing.
You got the order from the appellate authority?
In the voters list, her name is appearing. Only for domicile certificate is being denied, she is not being able to sit in the exam. Kindly, my Lordship.
So what the court will do? What the court will do?
Domicile certificate order may be given for the domicile certificate, my Lordship. Otherwise, a year loss will take place. For a student, a year loss is a big thing.
So what writ petition you filed?
For issuance of the domicile certificate.
So how the court can issue an order? It is the authority has to decide whether you are entitled to get the domicile or not. When you filed an application for getting domicile?
Application has been filed in past 2 months back.
এটা কালকে করে দিই কালকে করে
Madam,
Yes.
may I be permitted to mention?
Today is not the mentioning date.
Milord, may I be permitted to mention, Milord, we recollect
When it's going to expire?
Extension of interim order is going to expire 28 August.
28 August.
Yes, madam.
Okay, come on 27, mention, it will be listed.
Milord, we kindly recollect
Come on 27, you mention it, it will be listed on 28 as to be mentioned if it is not heard.
Milord, will kindly recollect the blood bank matter, Milord. Milord had been pleased to urgently hear the matter, Milord. There was a direction that the report will be filed by the state within 14th of August. Milord, till today, no report has been filed, Milord. Tomorrow, the matter is supposed to be listed, Milord. I am only paying attention upon notice that tomorrow some precedence may be given to the matter, Milord, because it's a blood crisis. Now there is a man-made blood crisis in this.
Let come tomorrow, we'll see what is the order. Within 10 matters?
No, Milord, that order was on the first day, Milord.
Correct.
Milord, that is the only prayer, Milord, that tomorrow.
Come on tomorrow.
But, Milord, I shall
Call the list.
My lord, one indulgence, my lord. May I be? My lord, one indulgence, my lord, 28 means my lord 20, my lord.
Yes.
Order has come up. Instructions which can copy of the letter.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submit that he has received a written instruction from the plaintiff petitioner that the petitioner is not intending to proceed with the case and paid for withdrawal of the writ application. On the basis of the written instruction from counsel for the petitioner, paid for withdrawal of the writ application. In view of the submission made by the counsel for the petitioner and the written instruction dated 8th August 2026, WPA number 11147 of 2026 is dismissed as withdrawn. Interim order is finished and vacated. The written instruction be kept with the record. Next.
Page 44 है.
2 नहीं, हम तो बोले इसको क्यों ऊपर रखा? 2 and 3 बाद में आएगा. पहले 3, 4, 5, 6, 7.
Again, in the name of the association, they have come.
4, 5, 6, 7 you call. 2 and 3 will take later.
Mala.
2 and 3 will take later. I told you why you had us come first.
সবাই এসছে তো
মামলাটা নাম কি প্রথম দাদা নামটা কি মামলা গুলি
Yes.
Now I tell you, Lordship, the situation has now little bit of change. I tell you, Lordship, there are in my petition there are 31 petitioners.
AG সাহেব আসছেন
Though I am not
he was supposed to be
18 petitioners now
covered
by the order of the municipality. I take your Lordship.
that not should be there.
I have given all of them the copies. Pagination না থাকলে যশোর দেখবে কি করে। Just a minute, ma'am. Then I will take your losses to the impugned order. But kindly see, this has been issued by the Barasat municipality,
Yes.
not by the municipality. This has been issued by the charged officer. Charged officer is one of the officer under the census commission.
Yes.
Commission, the census authorities. Your losses will get it.
Anup Kumar Sahu.
Barasaterটা কোথায়? Okay. Kindly see on 14th August 2026. It may be brought to your information that teaching staff of the educational institution have been deployed. The rules are act purpose. Have been deployed as enumerators or supervisors of census operation. Attention is invited to the provisions of section 51, 15A and 15B of the Census Act, which provided that stipulates no member of the census staff suffer any disability in service by reason of being on census duty, and the period spent on such census duty shall be deemed to be duty under his or her lending employer, and the performance of duties under the act shall not in any manner affect the employee's right to promotion or any other advancement in his or her original service. Then section 15B quoted provides protection to the census commissioner, direction of census operations, census officers, and members of the census staff against any suit or prosecution or other legal procedures. In view of the above statutory provisions, all headmasters and head of the institutions are hereby requested to treat the period during which the concerned teaching staff perform census duties as on duty under the respective institutions. They shall extend full cooperation by relieving the deployed personnel. Kindly consider the language. Relieving the deployed personnel whenever required and ensure that no service-related disability or administrative inconvenience or obstruction is caused to the discharge of their census responsibilities. As the census is a statutory exercise of national importance, all concerned are requested to render their wholehearted cooperation to facilitate the smooth, timely and successful conduct of the census. The memorandum is brought to the notice of the all concerned for strict compliance. Now, kindly see who has issued charged officer census. Under the rules, I will show your lordship the definition of the charged officer. Now, kindly have a look at the definition of the charged officer 2D. This and now copy. Copy. Now, my lord, kindly have a look. So therefore, this is not the municipality has issued. Municipality is, my lord, doing the entire arrangement of census work. Now, this is being now taken over by the census department and census officers has been issued it. Kindly see, my lord, to whom this has been forwarded. The headmaster, headmistress at the bottom, teacher in charge of all higher secondary schools under Barasat municipal jurisdiction. Then again, all primary schools under Barasat municipal jurisdiction. But I give your lordships one data to your lordships. Out of 31, 15 petitioners are Barasat municipality within their schools. 15.
Which one?
Malad, in the Malad,
which are they?
Onkon Sarkar. Malad 1 to 5.
1 to 5.
7 to 13. And 16 and 20. Now your lordships, petitioner number 22.
16 and
20.
Yes.
Petitioner number 22 from Govardhana municipality. You will just take note of from this bunch. I will show Govardhana municipality has also issued this notification. And petitioner number 26 from Murshidabad district. Your losses kindly take up. You could pagination করিসনি বোধহয় কি করে দেব pagination আমার handwriting. My lord, kindly have a look at my lord Murshidabad কি করে পাবেন জর্ষা municipality has issued
কত নম্বর দাদা
নাম্বার দেন
আমি ঠিক আছে আমি
13th August 2016
একবার নিয়ে নাম্বারটা দিয়ে দিন না এসব থেকে নিয়ে নাম্বার it will be easier for you also to show.
My lord, this is in this bunch.
My lord will get because otherwise my lord
the municipality my lord the same notification has been issued and Govardhana তোকে কাল রাতে বললাম
ঠিক আছে আমি
Govardhana municipality has also issued my lord. That's at page that's at page
there's no page.
August. The same officer in charge or charge officer.
Serial number 23 is not from Barasat.
Serial number 23.
He is also from the Barasat.
I just get your lordships.
On page
Malad, her school is not from Barasat. Malad, I am on the school now. Malad, I am distance. I will come later. Therefore, Malad, all of their census appointing authorities says this government West Bengal do this so that we can do it. Now your lordships, kindly have a look at this. Better copy. What the census authority says. Well, this impugned order should go immediately.
Narrated partner, these are this compilation.
Kindly have a look at other একটা copy দাও আমারটা আমি তোমাকে দিয়ে দিচ্ছি মানে kindly have this very মানে small letters names are there. I will be your lordships, kindly see at the bottom 16th August 2026 chart your lordships. 16th August, 17th August, 20th. It's a huge document I am giving as an example.
Yes.
Your lordships will find my census work start will at morning 9 a.m. 16th August.
Where from you're reading?
Your lordships.
It's molecule require magnifying glass.
So that one.
No, 16 August, which column?
column, my lord.
Yes, 16 August.
16th August.
Yes.
Kindly see, my lord. It starts at 9 a.m. It's written total building numbered, total census house is numbered, total buildings numbered. Then, my lord, duty ends at 16. That means 5 p.m.
Yes.
or 4 p.m. So it covers my entire school period, school hours. Like this goes on.
Now 13 means 1 p.m.
13 1 p.m. rest probably.
Then 16, yes.
And then
4.
16. The losses kindly see, then 17.
Yes, same.
Then 18. It
Same.
goes on mal for 1 month.
Yes.
That's why the census authority directed them so that they can get the work, treat them as on duty. Now your losses kindly see the impugned order. Just have a look at this. Impugned order at page 44.
Page 34.
Page 44, Malak. Impugned order.
Yes.
3rd August 2026.
Yes.
As directed, it is to inform him that census work should be done in such a way that the academic activities in the school are not affected. The teacher may perform census activities post-class hours and during the weekends. Lord, what am I to do? I am putting a question to myself. Now, my school is the lending authorities. I am under the Malad census authorities. Census authorities says come to at 9 o'clock. School authority says come to at 9 o'clock. This is the way they are performing the inter-census duties. That's why I have taken your losses to all the state authorities, common order issued. That look, when they will perform the census duties, they would not be asked to perform the school duties. Distance is not the matter. Why I am telling your lordships? Why the distance is not matter? Probably your lordship on the last occasion, whether the census authorities area in the school area, it's immaterial. Because I have to go in the evening. It's very, very awkward time, my lord, to perform the duties of the census works.
Yes.
It should be done in the broad daylight. Now, it depends upon, I tell your lordships, it depends upon also, now, I have to do the, my lord, almost the caste category also. If your lordships, my lord, see the entire chart, what I am to do, I will take your lordships to that also. Kindly have a look at the rules. My lord, your lordships, kindly come to the act first. Act, copy there. My lord, I have given on the last token and copy of the act. Act. Now, kindly have a look at this. Section 4A. 15A and B I have placed before your lordships. Section 4, capital A.
Yes.
Just every local authority in a state shall, when so directed by written order by the central government. This has now become a clash between central and state, or by an authority appointed by that government in this behalf, make available to any director of census operations such staff as may be necessary for the performance of any duties in connection with the taking of census. Now, my lord, kindly give a reasonable meaning to this interpretation to these provisions. I have been appointed as the enumerator or supervisor. I will show from the rules what are the categories of census offices. I'm one of the offices. I have been taken from the lending authorities for performing the census work. Now, my lord, what they have done, census authority says, treat them as on duty, don't disturb them when they will discharge of their duties as census. Now, therefore, my lord, the whole impugned order is contrary to the act of the census act. Then your losses will get it. Kindly come to the rules. Kindly, your losses will find census rules 1990.
Yes.
Charged officer I have placed before your lordships.
Yes.
The definition of the charge. Kindly see, my lord, section Rule 3. Next page. Appointment of census officers.
Yes.
The state governments and the union territory of administrations, in order to aid the taking of the census within the states or union territories, may appoint officers from amongst the category mentioned in column 2 as census officers within their jurisdiction with such designation mentioned in column 1 of the table below. Your losses will find column 4 and 5, supervisor, and 5, enumerator. Teachers, class, we are all teachers. Got your losses?
Yes.
Now kindly see 5. Say the functions of the, it's a full-time job for the period, particular tenure, 1 month tenure. Functions of the census officers. I am the one of the census officers. The census commissioner shall take, aid in or supervise the taking of the census within the country. Cause the directors of census operations to be appointed for each state and union territory as the case may be. Kindly see C. Devise the census schedules or questionnaires or provide to the state governments or union territory administrations for publication in their respective gazette to in order to canvass in the census. A questionnaire has been probably a lawsuit has also got in a lawsuit's mobile. It comes as a message from the census department. The 20 questionnaires you have to answer, and that has to be your losses filled in. And I have to go to the kitchen also, because I have to see whether there are 2 kitchen, 3 kitchen, whether the families are different within the same umbrella or not. These are the questionnaires, my lord. Complete and provide guidance to the directors of census operations of state and union territories in taking the census and computation of results. Publish the census statistics through publication of magnetic media. Your losses will find that elaborate details have been given how this is to be functions entirely. Now, with this, your lordships, kindly consider my amendments in paragraph. Just I take your lordships to my petition. Your losses will find census duties that catch the kitchen. No. I just take your losses. Paragraph 6. What are the duties now? The petitioner states that an enumerator must become familiar with the allotted house listing block. I have given you losses that this chart says house listed number. Approximately 200 buildings. I'm going to pause here for a moment. There is a difference from the rural area, the Mofussil area and the Kolkata area. Now, Mofussil area also having flags. One flag, premises, building is taken as an unit. Now, suppose 200 Raspberry Avenue. There are 3 blocks. Each block has 40 flaming units of flag. That means 160, but it will be counted 1 because premises number 1. So this is the duty I have to perform.
Yes.
In the Mofussil area also. And each building may contain 1 more than census houses. Verify its boundaries, number buildings, census houses, households, prepare or update the layout map, visit every building, census houses, household without omission or duplication, identify the respondents, collect the prescribed particulars. But I have to collect also what are their job, what they are doing, what the wives are also working or not. Maintain confidentiality, make repeat visits when residents are unavailable, and resolve locked house, doubtful cases, perform application database. Well, this has also an intention of the central government to find out whether there are other persons residing in our country who are not citizens of India. And synchronization, and submit records and respond scrutiny to supervisor. Then I have to sit with after submitting everything to supervisor, I have to sit with the supervisor. And then the data will be prepared. And then this will be submitted to the higher authorities. Now, this is the nature of work. In this bunch of, I have relied upon 3 census charged officers, a number of authorities. Now the point now comes up, your lordships. I have given your lordships out of 31 to a malad 20 suppose already covered by that, but that doesn't, because school says I'm governed by the order of my authorities. You have to come. Then where am I to go? This is one point. The second is discriminatory because some of them getting this benefit of on duty. But what about the others, my lord? Out of 31, suppose your lordships confined to the petition itself. 20 will be getting that benefit and 11 will not. Now, distance is not a matter now.
Okay.
These are my humble submissions.
Yes.
There are other programs, Madam, Nishtha program, all that. These
Yes,
are
who
the,
is appearing for the state?
but I'm just taking a short clip.
Yes. Tell me one thing. Municipal is not under the state government. So one authority, one autonomous body, or what we may say, he has taken a decision. Can the state defer that?
Those are two separate bodies, madam.
That's what I'm telling. Part of the state, part of the state. And if the census authority has fixed the time from 9 a.m. to 4 p.m., 9 a.m. to 4 p.m., have you got the instruction on that? What is the time duty of the census given by the census authority? Fixed by the census authority. Have you checked it? Whether your authority has given that instruction to you? Because I have given 3 days time to sit with the authority. Whether the census authority has given you the instruction, what is the time period they have to report, and from which time to which time they, because as per this chart 9 to 4 p.m. That's why. So how, if the census authority is of central government, correct. So if central government is not not consultation with the state government, and state government is not obeying the central government, how the state will function? Then that's why I'm asking, central government census department has fixed the duty from 9 a.m. to 4 p.m. And you are telling now your teacher will go after the duty hours or Sunday and Saturday. How the work will be completed? That is the only question. That is the only question.
We also have an obligation under the Right to Education Act. But we also have an obligation under the Right to Education.
Correct.
So under the Right to Education Act, it is we cannot allow whether we will fall out of that obligation or not.
So then you not to appoint the teachers. You go and implement the RT Act. Not to give the duty of the teachers, because the RT Act will be affected if the teachers will be appointed for the enumerated or this for the census duty. Not to appoint the teachers, because I am sitting here and you go to the revenue office. None of the officers will be available in the office, because they will say I am in the officers on the census duty. It is correct or not? Or I will send a special officer from here in now to the revenue department. Bring one document. I will say only one officer will be in department and nobody will be in the department. They will take their in census duty.
As per I borrow that is fair. But as per the census rules, it was seen of 1990. Rule 3, enumerator, my lord, is given to teachers.
Correct. That's I'm telling. Teachers class. So if these rules have been framed, taking into consideration of the RT Act. So then you file an application. I will set aside the rule. It is a virus, because RT Act came later, subsequently, not taken into consideration of the census act. So it is intravirus or ultravirus, whatever it may be.
Our job is to harmonize, madam. Our job, madam, as the authority, madam, our job is to harmonize. So that's why we are balancing, madam. But why, madam? From see, almost all the teachers, almost all the teachers, my lord, are from my lord private. My lord, now, my lord, last teachers has the distances, my lord.
Correct.
My lord, distances, my lord, will be peaceful.
What your authority has taken the decision, tell me, and then I will dictate the order here. Now I don't want to waste the time. Tell what the authority has given the instruction, what decision has been taken, whether they will continue with the order date on the impugned order of page 44. They wanted to continue, then I will pass an order. I don't want to waste the time.
Because it went from my lord, it's instruction.
Correct. But subsequently, one of your state authority, you also go through this. You also go through this. You also go through it. Then your authority cannot disapparate. Then just that is the municipal authority pass an order, but I am the education department, I will not pass an order. In one state, two authority can take the two decision. Now the situation change. On that day, there was situation different. Now the situation change. Your one authority accepted what this court has given thought of. No. 14th August.
He got it on 14th last time, but we used to.
So you had on when you had a meeting. When? Friday. If you had a meeting, so on that day census authority was not there. Because this order was passed by the census officer, not by the municipal authority.
But as far as that, census instructions are. But as far as this is concerned,
10 a.m. Okay, I will record it. They will only work for the 10 a.m. On subsequent they will work, and the census authority will change the work schedule. I will record your submission. I will change the.
Other private hours.
Okay. And what have you taken the instruction? What is the time duty allotted by the census officer? Because they cannot directly go, they have to report to the supervisor. So where they will report? Your authority is not having the update. Your authority, you are given this. Have you gone through this? Which year? Then today the same time is maintaining. So today the same time is maintaining. Who has given this order? Let he come at 2 p.m. here in person. Who has given this? Given this instruction to you? 75 till 2025, the timing, the school timing has not changed. How you are appearing for the authority? This is the way the authority is functioning. Yes, Mr. ASG, what is your submission? It said is failed. I will record here. I will record the judicial order. State is totally failed to appoint a competent officer to place before the court matters. No. Your authorities are playing. You are for the central government. Central government is issuing some notification. You are not satisfied the state government. There is no cooperation with both the governments. Your census officer is telling that the duty should be 9 to 4, and they are coming with the 75 scheduled time of the school and threatening in the newspaper. Threatening in the newspaper.
Is concerned, my lord, because my lord, as placed before your lordship, 15A and others, Census Act, we have to work according to the Census Act. Now, lordship, what we do is we serve a notice that, look here, y'all are the lending authorities, y'all lend it according to the rules which are governing the field. My lord will kindly appreciate. Now, lordship, what happens is that when we give this, we are well within, we never say that you don't follow the Census Act, because that is the whole and soul of the entire process. I cannot go beyond that. Now, lordship, if 15A prescribes that it is within the time limit, then the lending authorities will adhere to that and work in consonance. Now, lordship, what has happened is, what I understand, perceiving with the deepest of respect, because of St. Mary's judgment and because of the judgments following that of 2010 Allahabad and recent to 2025 Allahabad, I'm showing it to you, lordship, will kindly just give me 30 seconds. Just in order to say what I'm trying. Now, lordship, as far as teachers are concerned, lordship, the school authorities may have, the state authorities may have, I cannot champion for their cause, may have issued, as far as teachers are concerned, they have adapted this particular notice, and as far as municipality and others are concerned, it is not that. If my lord kindly sees that that compilation.
The municipal authority, it is not with regard to the area, not the municipal authority. It is the area where the teachers have been given the work from 9 to 4. It is not that the municipal employees have been given the work from 9 to 4.
My lord, I'm not saying that. What I'm saying, yes, my lord, as far as census is concerned, my lord, this document is concerned, we are going from 9 to 4, going by 15A, if my lord kindly appreciates. Now, lordship, the lending authorities, what they have done is, taking in view St. Mary's judgment and other following judgments, they have made, they have called out a different schedule or a notice for the teachers saying that, look, in the light of these judgments, you have to work. Now, lordship, what has fallen from my lords, I also bow down, that, my lord, it becomes very difficult. A particular notification which has come and which is not practical enough, and it has an applicability and execution problem, should be modified. And therefore, my lord, the judgment which I am going to cite, it is not saying that, my lord, whatever they have said is correct. It is saying that just because of the St. Mary's judgment and act, there should be a consensus between the census and the notification, and you should give certain benefits to teachers. So, my lord, what has happened is, my lord, as to why 15A and 15B of the Census Act has not been adhered to, my lord, I can understand this is the reason. So, my lord, what I'm humbly, because census, we will have to act in accordance with the act. Census, what it does, lordship, when it starts, it has prescribed ways of working under the Census Act and rules framed thereunder, and they just said a notification that this is the timing, from this timing to this timing. We need people who are to be lended by the state government from various institutions, made municipality, made teachers. So, my lord, this is what my humble submission is, my lord. Now, my lord, I can get this also in writing, my lord, because the lending authority.
No, what would be the fate? What would be the conclusion?
My lord, conclusion will be this, lordship. In the light of the judgments, my lord may borrow, my lord, my submission.
Yes, give the judgment.
Yes, my lord, 2025. My lord, because, my lord, I render unqualified apology. My lord, we are judgment copy nahi. कोई दिन देवा है
Within the world.
ना ना
No, no, nowadays juniors never work.
मतलब
All are in finger.
मतलब
All are in finger. They never read book. They never get the citation. All on laptop and mobile.
2010 मतलब kindly say this is 2010 judgment and lordship it may be Miller 2000 judgment is in my lord's record. If my lord not then we are giving 2010.
Yes.
Na dichi 2000 citation time আগে তারপর আগে
কোনটা সাইড করছো
2010 ইলাহাবাদটা পড়েছিল
2010 এলাহাবাদ পেজ
এক নম্বর
বার করো
Yes.
SCC online Allahabad 1107. My lord will kindly have a look at this judgment, my lord, taking in view. My lord will kindly take up the paragraph 6, my lord, paragraph 5 in my respective submission.
Yes, what the last two line on Friday I said
that is what Millard. I am what I said at the very outset, Millard. This is just in order to, my lord, will say that this is what has been done because this problem was cited by the honorable courts pan India, saying that they cannot be contrary views because 15A should be taken now. St. Mary's, which is there, lordship. Paragraph 33, my lord, kindly sees. 2008, volume 2, SCC 390. Lordship will kindly see.
Paragraph 33.
My lord, now this particular judgment of the Honorable Supreme Court, which was followed after this paragraph 33, my lord, kindly sees. After this judgment,
paragraph
33. My lord, has got it?
Yes.
Now, my lord, this being a law under Article 142.
Yes.
Now, lordship, then Millard's, there's 2025 judgments on the same line where the Honorable Single Judge of the Honorable Allahabad High Court has said that there should be a consensus. So, my lord, what I am humbly submitting, with deepest of respect to my lord, is my lord that my lord, maybe my lord will have to pass an order in a fashion, my lord, maybe my lord, kindly not take.
The court
Because,
will
my lord,
pass an order unless and until the court can get something from you. You persons are not able to give the which school, how many teachers have been given the duty, or how many non-teachers, non-teaching teachers, and whether what is the time period. He has given the time period of 75. Now the teachers are telling that now we are working in 10 to 4.
10 to 4.
And he is telling the 75, 6 to 10. I don't find in the Calcutta 6 to 10 any school is going on nowadays for the last 6 years.
At least, my lord, there are school from 8 to 3. At least.
My lord, I got instructions of 20.
That's English medium.
The morning and day session end at 10:25 a.m.
Now, there is no morning section in primary school. Sorry.
Day and morning sections ended 10:25.
So, integrated school.
But I do not know why Mr. Shanti is saying
Now
that.
today
Of
there is
course,
no.
those are integrated schools.
If Malot took us on this, but at least they should have stood there and Malot.
Okay, whatever. So that if that's why you are given to sit with the authority and come with the data. You are not, your authority is not able to give the data to you, and another authority is passing some order which you are accepting. You are not challenging this order of the census authority. You are not challenging this order.
Census authorities' order are contrary to this education
Correct.
department's order. Which
And,
one will prevent it?
and the duty hours which the census authorities are fixed, how this order can be fitted? Order of the Supreme Court, how the order of the Supreme Court can be fitted with the duty hours fixed by the census authority? These are the 3-4 questions are there. The court is bound by the order of the Supreme Court. The court has to follow the Supreme Court guidelines, but simultaneously this court has to see whether on the line of the Supreme Court order, whether the authorities have acted upon on the line of this time fixed by the census authority.
Consider duties of the election commission.
You tell me. That's why on that day I have given the 3 options: either give the half day leave, or give to not to work on Saturday, or to come. Yes, there are 20 teachers, only the 5 teachers will go on duty, and the 15 teachers will be adjusted for.
May I tell you, Losses, one thing? Suppose teachers are giving.
Last day they came and said, this is the dispense. I handed over a document to them in Prashant Chaudhary matter. Not one person.
The distance become immaterial now, because immaterial.
My landed without
immaterial.
Just one person, one time one person. That's I appreciate, but tell me how it is feasible. That's why you give me timing. Yes, this time to this time the teachers has to work. Then I will direct the census to with regard to this petition.
Suppose your lawsuit follow the judgment of the Honorable Supreme Court. I have to do work on Saturday. I will do it. But it can't be finished within a month.
Correct. That's what I'm telling. Because Supreme Court has passed this order. Whether that time, I don't think whether the time was there or not. Now you have fixed the 1 month time. So 1 month time.
Primary schools are there.
1 month time. So how the 1 month time can be?
Because last week said they said 50,
I appreciate. I have gone through. But now your authority have put you in trouble. Your authorities have put you in trouble.
The other
whatever, I don't know, other or either, I don't know. Your authority one authority is taking some decision, one authority is taking some decision. If suppose you are telling that education cannot do, so how this order will be, 14 August order will be implemented? If I will accept your submission, so how the 14th August order will be implemented? No municipality, census officer order, charge officer order. It is not a competent officer. Competent officer has passed an order. If you are implementing this order, so why not to the other teachers? So where is the parity? Where is the equality? Then you are not challenging this order. And second, this is the duty hours of the census authority. 9 a.m. to 4 p.m. If 9 a.m. to 4 p.m., so how on the Supreme Court judgment can be implemented, carried out? So that whether the judgment of the Supreme Court, the facts of the judgment of the Supreme Court, the facts of this case, distinguishable or not distinguishable? Then
so these requirements are there.
See, adamancy of the department and to go by the law, there are 2 things. Adamancy will cause injury to all persons. If you ignore the law, keep it in mind. And always the senior officers, IAS officer will adamant. And that's why the government has appointed a competent lawyer to say the officers, this is the law. If the officers of the court is not able to satisfy the officers, then I don't know whether the officers is competent or not. Thursday I have given the time. You have taken 15 August is holiday. I have given 1 day, but no fruitful result has come. What a development? If your development, you could have been either adopted or you challenged. You have not done so. Neither you adopted this nor you have challenged this. 2 days has waste. 1 month time is there. Tomorrow you will issue the so-called notice to the teachers you are not attending the census. Who will take the responsibility of that? No, I am telling.
The instruction is different.
Apprehension.
Work has started. Now school is taking another attitude. They're putting me in absent.
That's why.
How do I work?
I don't know. I am not going with the Sanyal. Sanyal may say, but I am telling in apprehension.
Individual.
Correct. No, differently means because the other writ petition, in other writ petition, I am telling, I am knowing. In other writ petition, what is up? This court has allowed the teachers to go for the 2 years training, daily training. Supreme Court has allowed that. On the basis of this court order and the Supreme Court order, the teachers have been released to go and join the training. They have joined the training, that is a regular class training. In spite of that, having the order of the Supreme Court, having the order of the High Court, you have given the time schedule for training. So how they will pass? Only within 2 years they have to clear the delete examination. Then I pass an order setting aside your order. Then again you have given the census duty, ignoring my order. Then that's why I am not taking on that day. I will take today, and what is the consequence I don't know. I have set aside that order not to send them to any training unless and until they complete their examination of the delete course, because they are conducting, they are appearing in the course in terms of the order passed by the High Court and the Supreme Court, and your school has released them to appear as a regular teacher, a regular student. Then this is the way the state is functioning.
What I think.
It should not. My lord will be.
So there are many cases. Every case is having. That's why I told. That is a different facts. Not on duty work. You have to treat the on duty. There is no such thing. You have to treat the duty. Only the question is that which time to which time they have to go for the census duty. It is not your sympathy that is treated in duty. The law provides treated in duty. But the only question, which time to which period. Because as per the census, 4 to 9, 9 to 4.
That census authorities give a direction in a modified manner.
So you take because the court cannot direct the census authority to modify your order because they have fixed the time, because the time is the 1 month. Time is 1 month. So why there is no coordination between two departments? Why there is no coordination with the census and the state authority? Why? Or otherwise I will see, because I will call both the authority. Because in one case, once you have taken the decision, why you are harping upon the school duty? And you are telling that the RT Act, then you not to give the work to the teacher. So then, so balance is to be given. So balance is to be given. Still you are not able to, the teachers, in which school you have given, how many teachers are posted? And how many teachers have given the duty of census? Can you say? You have a data? No, data of the school and the teachers who have been. With regard to these teachers? This petitioners? You're not.
We do not have mallet. We will have to mallet just.
Yes, Mr. Trivedi, what can be done? You are harping upon time. He is harping
I
upon.
am not harping up. My lord, I am not harping upon time. Lordship, the problem is that had it been 1 year back, I would have sailed through. Because, my lord, but we have now this luxury of sitting down with the state government and planning out a point. Otherwise, if it is, my lord will not take me as far as censor authorities are concerned, rules are concerned, my lord. We are wanting lending of officers. Lordship will kindly appreciate.
Yes.
We want 1 month. We have given 9 to 4. Now, Lordship, whether the lending officers will come from municipality,
anywhere,
whether from school. Now, Lordship, it is the state authorities who will, because, my lord, as far as teachers are concerned, St. Mary's comes into play. As far as others are concerned, not. 15A is there in order. So 15A is there in order. That can be applied to all other employees except teachers because of 142 article. So only when teachers are concerned, then only you have to carve out a particular plan for them. That St. Mary's direction as far as article 142 is concerned is also taken care. There you have to act as a trapeze artist. Now, that is the only contention. Now, Lordship, as far as census authority is concerned, I am asking a question to myself. We have given a generic thing that we have to complete. So from 9 to this time. Now, Lordship, the lending authority will say that these teachers are there, which needs an amendment. So we will say, all right.
No, in that case, again,
yes,
if the time is amended, because your authority have fixed the time 9 to 4.
Lordship.
And completion time is 1 month.
Lordship.
Correct.
Lordship.
If suppose today the court direct, okay, taking care of the RT and for their consideration, okay, half time they may be from, if it is the 12 noon onwards they will be. But whether that the period 30 days will be completed.
My lord, may I answer very humbly to the two portion. 1 month will be complete. First point, my lord, what I was humbly trying to impress, even wasting my lord's time for 1 minute. Now, my lord, as far as we want officers to be lended to us to work. Now, Lordship, whether 1 month we'll complete, otherwise we will extend the time. But Lordship, as far as we are concerned, my lord, if we do not fix a target, dereliction will start, procrastination will work. So what has happened, the target, Lordship will kindly appreciate the word itself. Like tomorrow never comes. As soon as it comes, it becomes today. So target is a word in English language which need not be completed, because if it is completed, it is no more a target.
No.
So, Lordship, what we are saying, as far as extension is concerned,
that's why there is a word of extension.
Lordship, very rightly fallen from my lord. My lord, so my lord, so therefore, my lord, I am giving so target, my lord, it is always amenable to extension. Now, Lordship, time from 9 to 4 is concerned. As far as the school teachers are concerned, this is the problem which is to be faced by them, because you have to maintain a very delicate balance. In view of Article 142 and in view of the Census Act. So therefore, so what we want, my lord, what I wanted to sit down, and I understand that you give me a list of teachers for which we will say, or my lord, no list of teachers is also not wanted. What we are saying, as far as our work is concerned, you say that these people are teachers, so they will go after 4 p.m. or maybe they will go at this PM and they will work less, and you supplant it with other officers who may, because work can be done by any officer. I don't need
specific. It is not teachers only.
It is not only teachers, and this problem is only available with teachers because of the act.
Correct.
So, Lordship, what I'm humbly submitting is that, Lordship, it may fall from my lords if my lord so deems fit and proper. And that as far as teachers are
concerned, you are taking the so much risk of the RTI, because all the other states are not taking the RTI so much serious if the teachers have been appointed. Why your authority is so much harping upon the RTI? What is the reason on that? So not to appoint the teachers, non-teaching staffs may be taken to, or the other municipal panchayat, Zilla Parishad, and your clerical staff, your parliament, the assembly staffs may be taken for the 1 month.
We have cited 2-3 states order.
Clerical staffs, how many clerical staffs are there in the assembly? Give them.
বড় বড় স্কুল থাকে ওইটা এখন ওইটা তো বলছি
Not spare. I am asking if it is a difficulty. So
my lord, it can come to this census if the state now comes that this is the only problem, my lord, with regard to teachers. As far as so, they should amplify the numbers of other government employees from other respective department, which is not governed by the diktats of the Honorable Supreme Court. And maybe if then also teachers are required, it should be used to the minimal. That will
That's
serve
what
the
I'm telling.
that will serve the
unless and until you will not identify,
Lordship.
it is very difficult, sir.
For this issue, it should be more at a because in the education department, departments are good in sense of work. So that's how they comply with the order. It has been sent directly.
Can you have any idea how many teachers have been deployed for this?
On the entire exercise.
You know, no idea how many teachers.
Because that is because these total things are
So okay, what can I dispose of this writ petition?
should I, my lord, should take a chance to look at resolving this and
But 2 days has passed, and they will be in difficulty. Your school will take further steps against the petitioners.
it has not happened as of
No. Yes. If my learned friend wants, my lord, if the course of the day, my lord.
And with regard to the
Name of the
who is conducting their training and the delete course, so they delete course, they there will with the shortage of their attendance, then they will be debarred for appearing in the.
I will definitely find it out and I will.
My lord, exam schedule has been given.
তুমি যেটা দিচ্ছ 5 নাম্বার
Exam schedule has been given, my lord.
Once the exam schedule has come, 8 September. So if they will go for the census duty, where they will prepare the examination.
My lord, I'm not saying what the officer has said in the open court.
Come tomorrow.
My lord, I have nothing to do. My lord will kindly appreciate my.
Hey, Mr. Trivedi.
My lord,
Please you sit with the state authority. Please you sit.
My lord, I went myself, my lord, to the learned AG's office on Friday. My lord, I don't want to say. I went and I myself personally, lordship. On Friday, I went. Yesterday, I spoke to my learned friend and also to the AG. Now, lordship, as far as census act, my lord, I have, to my best of ability, tried to explain to my lords that we have given a timing because we have to complete it. Extension is concerned, we will do it. But lordship, a target has been given. Now it is the lenders who will, if they have any problem with the teachers, they tell us because they are the lending authorities. It is they who know how to meddle with their employees. I am just asking for a outsourcing.
Counsel for the parties has argued the matter at length. Police counsel for the state press for a day's time to take instruction. According cases are let the matter appear tomorrow under the same heading at the top.
Item number 5, I have filed supplementary affidavit.
Yes.
And my lord, in the meantime, my lord, at least verbally, my lord, if the understanding, my lord, did not make it.
Yes, Mr. Please, kindly see this petitioners.
My lord, I will talk.
Please see this.
Take a couple of days, but seeing the gravity of the matter, my lord.
Now, with regard to the item number 5, see the petitioner's grievance. My order is there already there. Correct. Not to let they continue because the exam is going to be held on September. Come tomorrow.
Absolutely point.
दादा एगुनो नहीं है नहीं
Yes, next.
तो बाद में
सब कल आएगा. 1 and 2 also tomorrow. 2 and 3.
2 and 3
2, 3 to 7, na? Come.
2 and
6.
2 and 3
Tomorrow, come tomorrow. Let us solve this.
सब तो एक ही होगा ना.
I don't know whether double engine government, why they're quarreling.
We are not quarreling.
They should have been a.
That's why, Mr. Bhattacharya, I have wasted 1 hour time.
We are not quarreling. Whenever you come there,
Because this situation, if it is so,
It is not, my lord. I lay clear before my lord. No quarrels, my lord.
that's why I'm asking both of you to sit together and come.
my lord, at the very outset, I said, had it been 1 year back, today, to my lord, I am trying, my lord, I'm trying to save the situation. I'm grateful.
Yes.
नहीं वहाँ लग गया सीधा, उसमें कोई ऑर्डर नहीं होगा, कल ही होगा। 2-3 भी कल आएगा, 2-3 से लेके 6 तक का कल टॉप में रहेगा। यस
Well, item number 7, your lordship, kindly take it up the tomorrow or day after tomorrow.
What is the matter?
Mr. I'm led by Mr. Sanal, my lord. You are taking on legs, my lord.
What is the matter?
The matter, my lord,
Regarding my lord, the defalcation of money of
it is, my lord, India.
yes.
It's not appearing for the petitioner. He is appearing for the Union of India.
You are for the petition.
No, I will respond.
Which is the petitioner? Who is for the petitioner? Yes.
Well, I have not
Here,
received the Haladdama.
Here, Miller, this is a case, Miller, paragraph 3, Miller, which states, Miller, the locus of the petitioner. I am a life member of the Indian Congress Society, Miller. This was first, Miller, chaired by Miller, Sir Ashutosh Mukherjee, Miller, the Honorable Judge of this court and the Vice Chancellor of the Calcutta University. Now, Miller, this was done, Miller, way back in 18th century, Miller. One of the propounder of such society is Sir McMahon. And Miller, this was done that the meeting of the greatest mind in the scientific area, that was one of the necessities and objectives, Miller, for the advancement of the research in the scientific area, for which, Miller, this was done. Miller, the society, Miller, says, Miller, that election has to be done, Miller, new formation of the committee as per, Miller, the regulation 15, page 27 and 39 of your lordship's brief. It has to be, tenure is for a period of 1 year. Now, Miller, we have two separate complaints, Miller, alleging, Miller, that there is rampant corruption and misutilization of the public funds, Miller, for which it was constituted. The state under the Society Registration Act 1961, Miller, it must cause an inquiry. The authority, Miller, maintains silence and specific application that there are certain, Miller, things which need to be looked into. Now, Miller, I, professor of statistics of a particular college, I said that this statute, as such, Miller, the justiciability of the issues, Miller, is not is not in doubt. So, Miller, on this score, Miller, we made two representations. One is 6/5/2026 and another is March last 2026. Now, this, Miller, representation has not been answered to the respondent. Yes. That is, Miller, last meeting held, Miller, 7/1/2023, and the representation, Miller, the complaint, page 54. 54 is a complaint. Is a science and technology, Miller, I raised the first complaint. And now, Miller, Mr. Shan, senior friend, do not that who is his client, but I have a specific, Miller, that is why I know, Miller, with certainty that, Miller, the existence of his client, Miller, is under suspension, and, Miller, there is no possibility, Miller, his entire existence, Miller, is in limbo. Now, Miller, the central government and the state government possibly, Miller, yes, and that too, Miller, Mr. Bishwa says that his client has not given the Vokalatama. That is maybe one of the reasons that, Miller, that is why they hesitated to hand over the Vokalatama, because their existence is in limbo.
No, what my landed.
Let him speak.
Yes. Now, Miller, the representation, Miller, the first complaint, 54. Yes. 54, Miller, I categorically say the present corruption related issues of authority of historical institution related to science and technology. This is to bring to your kind attention that the ongoing has been the of the case, newspaper of the historical institution of science in the country. The Indian Science Congress is science.
Who is the authority to consider this?
State government.
State government.
Yes, and Milord kindly ask me that
No,
the
you
government-
you send this to the secretary minister.
Yes,
sign
then
and
Milord,
then
I
you
made a
process.
complaint 24 thereafter to the Milord register, page 55. I'm
Yes.
sorry, Milord, page 55.
Yes.
I categorically. Yes. Now, Milord, I such and such, recently I have observed gross violation of the West Bengal Society Registration Act by ICICI authority. You are requested to note that the election of the
What is the allegation? What
allegation, Milord, I categorically state, Milord, the non-pursuance of the bylaws of Indian Science Congress is the present form are not registered to the register of the West Bengal Society with the regulations of West Bengal Registration Act. The last registered amendment was in the year 2000. Some example of gross violation of regulation with the Society Registration Act is listed as below. I have enumerated what are the violations. I categorically state that the illegal election of the categorically state that.
So who is not in the executive committee at present?
Tenure has ended. Regulation 15, Milord, page
Now,
27.
Who is controlling the
Milord, there is a total chaos, Milord, administrative vacuum. Milord, government, Milord, Milord, the element of corruption, Milord, and also, Milord, this irregularity, because there is a huge fund. There is a huge fund. I apprehend, Milord, this public money may be misutilized. The government has taken certain steps. I have a definite information.
Yes.
Lord, may I speak? Appearing for the respondents number 11, 12. Please allow me. Please allow me. I will answer to all questions. You have.
Milord, I am appearing for.
Then your losses. Let me go out of.
Milord, I am appearing for.
You are appearing for whom?
I am appearing for my lord past general secretary and 11 and 12.
Okay.
My lord, I tell your losses. My lord, kindly have a look at the complaint against the before they register at page 55.
Yes.
Now your losses kindly go through this along with the other representations to the ministry. Your losses will find that at page 76. Both are Malad intermingled. Malad, let go by Malad page 76. The first clause, there is no general body meeting. This is the first allegation. Or annual general meeting organized by ISCA, Malad, the commonly known Indian Science Congress Association. In the accounting years, kindly record that, Malad, kindly take note of. 23-24, yes. 24-25, 25-26.
Yes.
Malad, my first point is the collusive rate petition between the central government and this person. This person has been projected by the central government. Malad, what happened, Malad, is a society under the Society Registration Act. It receives certain grants and the rest expenditures are done by own. And this Malad grant, according to us, we are getting from central government since 1972. According to the central government, since 1942, 47, all that. Accept that. Now, Malad, what they did, they changed my bylaws and regulations under the society registration unilaterally that you have to obey because you are taking grant. We moved this honorable court. Honorable court quashed this order. Your losses will find it, this judgment. Kindly have a look at it. This judgment. It's a big, longest judgment. This was passed on, your losses. Kindly take note of 2025. This contention was going on from 21-22.
Yes.
What happened, my lord? We succeeded. Entire thing has been quashed by the single judge. Now, my lord, they have preferred appeal. There is no stay. Even today, my lord, on the last occasion, they have concluded. Now, today at 12 p.m., the matter will be taken up before the Honorable Division Bench. And, my lord, my turn comes at 12 noon. I will argue. Now, what happened, your lawsuit? Because of this, but the entire thing has been occupied. The entire office has been occupied by the central government officials. That's why we could not hold the elections. Our bank account has been freezed. We cannot do that, our elections. And this person being a member doesn't know anything. Then he doesn't deserve to be a member.
So whether 23, 24, 24, 25, 25, 26, whether any election has happened?
Nothing. It will not be because of this. Because of this.
So your case is that this is depend upon the judgment passed by the outcome of the division.
This is the thing, Your Lordship. Therefore, this should not be heard today even.
My lord, I am
This
appealing
is
for union of
petition. And kindly see what are the allegations, the other allegations. They are making these allegations.
Mr. Basu, if it is a division bench pending in this order, let.
My lord, may I just submit? I am appealing for.
Successful plea was taken.
And I tell you, Lordship.
My lord, I am appealing for respondent number 4.
Understand this tension, my lord.
Your case should not more than that.
Page 74.
No, these are my humble submissions.
Yes, yes,
My lord, may I indicate, my lord, something.
Yes.
My lord, I am appealing for respondent number 4.
Ah.
My lord, so far as the allegations with regard to, my lord, the order is concerned, my lord, the order was totally on a different. There, my lord, some amendments were brought forth by the Union of India in order to, my lord, change the bylaws. That was under challenge and subject matter of the writ petition. My lord, we lost. And my lord, the appeal preferred and appeal is pending right now. My lord, Lordship kindly sees, my lord, this is, my lord, the Central Vigilance Officer's report regarding the defalcation which, my lord, the petitioner is alleging.
My lord, this all were placed before the petition bench.
We have not disturbed you. Lordship kindly sees, my lord, this is 100% grantinoid Institute of Union of India, controlled as an autonomous institute under the Department of Science and Technology. My lord, these, my lord, funds are, my lord, being given, my lord, since 1947. Now, my lord, they don't have any self-generation process. The union's, my lord, total budgetary fund is accumulated and lying with them. Now, my lord, they are, my lord, by way of.
Yes.
Lordship kindly sees, my lord, the
Now it has gone to
allegations.
the CBI.
Yes. Now, my lord, it has to be, my lord, inquiry has to be done by the CBI. It is totally, my lord, controlled under the Department of Science and Technology. And, my lord, they are, my lord, representing. Just ask this question myself. My lord, the executive committee has become defunct. The annual general meeting is happening since 20.
Appearing for the authorities 1, 2, and 3.
Only before, my lord, I lordship has raised a very pertinent question. I am only, my lord, confining myself. I will show your lordship 2 pages, section 23. This is the scope of the writ petition. I am not inviting this honorable court to decide anything. Number 1. I am only asking requesting.
Now, Mr. Basu, once the matter has referred to the CBI.
No, when it is CBI.
Refer to the CBI.
Yes, Lord kindly comes to page 74 once. Then CBI file a report.
That's right, darling.
CBI.
So that's why I'm asking who is suffering for the 1, 2, and 3.
Is the CBI.
Huh?
CBI separate panel.
One
He's
is
happy. She's
State
happy.
of West Bengal. No, that's correct. Now I wanted to what is the fate of this complaint given by the one of
Chief Vigilance Officer.
By the vigilance officer to the CBI.
My lord, for that, my lord, my humble submission, my lord, the CBI should be implemented as party respondent.
Give me leave, my lord. I shall leave will be granted. I
These all.
No, he cannot have any.
My learned friend was not, senior friend was not there. My learned friend is there appearing for the Union of India. Mr.
By the for the department.
They have, this allegation. As of today, no copy of the allegation has handed over to me.
It is confidential.
Honorable single bench as well as the division bench. But the allegation, my lord, we have all the answers.
Look, this is a confidential document.
My lord. But as of today, my lord, neither the single bench nor the division bench has taken cognizance of the allegation of defalcation, my lord.
But before the honorable single bench, totally different issues. Before the division bench.
My lord, this is only, my lord, to take control the, my lord, entire, my lord, the affairs of the, my lord, society.
Okay, CBI file a report.
The
anxious. So if your lordship, my lord,
the grievance of the petitioner is the present application that the petitioner has made a complaint to the registrar of firms, societies, and non-trading corporation, government of West Bengal on 11th of March 2026 on the allegation of anomalies in operation of Indian Science Congress Association within bracket ICSA, as well as on 25th of May 2026 to the Principal Secretary, Department of Industries, Commerce and Enterprises, Deputy Commissioner of Police, South East Division, Kolkata, and Officer in Charge, Karaya Police Station. But No steps has been taken on receipt of the complaint of the petitioner. According, the petitioner has filed the present writ application, praying for a direction upon the authority for consideration of the complaint made by the petitioner for taking appropriate steps. Learned advocate appearing for the respondent number 3 has handed over the letter dated 28th of October 2024, wherein it is found that the Chief Vigilance Officer has referred the matter to the Central Bureau of Investigation, Anti-Corruption branch for taking appropriate with the request to investigate the case. He submitted after that the case full stop. Considering the above, this court finds that the Chief Vigilance Officer already referred the matter to the CBI. Accordingly, CBI is the necessary party in the present writ application. The petition is directed to implement the CBI Central Bureau of Investigation Anti-Corruption branch 14th and 15th floors, second MSU building, 235/4 AGC Bose Road, Nizam Palace, Kolkata, as respondent number 15 in course of the day, and to serve notice upon the CBI. The CBI is directed on receipt of the writ application, CBI is directed to submit report with regard to the action taken on the report submitted by the Chief Vigilance Officer dated 28th of October 2026 and 2024 on the next date fixed. This is the matter on 2nd of September 2026 within
Leave may be
20
granted
matters.
to add CBI matter at the party.
Within
Leave
10
to
matters,
apply. Extremely great.
affidavit of the petition director to file the affidavit of service showing the service upon the CBI on the next date.
Lord, one humble submission, my lord. Since I have placed, my lord, the document which is confidential, if your lordship kindly place it under sealed cover, my lord. Otherwise,
The communication submitted by the respondent number 3 be kept in
respondent number 4.
respondent number 4 hoega, be kept in the sealed cover.
Grateful.
Next.
I appear, my lord, for the writ petitioner in this matter.
Yes.
Lordship, my lord, may recall, my lord, this is a case, my lord, where, my lord, there is a question of infiltration. Yes.
Item number. Yes.
Yes. My lord, the issue is, my lord, the so-called, my lord, the persons, my lord, against whom the complaint are, my lord, they have, my lord, infiltrated to, my lord, India, and my lord, they are holding Bangladeshi passports. And my lord, they have come to India via, my lord, tourist visa and medical visa. The mother of the, my lord, the so-called husband of the petitioner, my lord, this is something, my lord, she got married to this person in Guwahati. Subsequently, it was discovered that, my lord, this person is a Bangladeshi citizen. My lord, all the Bangladeshi papers, my lord, were there. My lord, we have also, my lord, this is all there on the writ petition, my lord. Kindly, but I can recap, my lord, those issues. But on the last occasion, Lordship was desirous that, my lord, the Election Commission as well as, my lord, the Union of India, my lord, should come up with the reports and, my lord, to serve us beforehand so that we can take any exception. My lord, we have been given the report, only a one-page report from the Union of India today. My lord, we want to take some exception, and, my lord, ECI has not yet come up with anything. And, my lord, we have
1 week time. 1 week.
You are appearing for whom?
ECI.
ECI. Mr. Datto?
But I appear for respondent numbers 12 to 15.
12 to 15.
The private respondent, the allegations are against my clients.
Yes.
But if the reports come, will not.
FRR. We have filed a report, one pager only.
My lord, something has come here. My lord, that is a my lord, that, my lord, I don't know, my lord, senior friend has not been. See this? This is the EAFRO report. This shows that this mother of the so-called husband had come to India through a medical visa. This is exactly what. It is not there. I subject to correction.
Which we have only sent this page.
So that is why I want to also assist my learned friend. My lord, I'll file an exception to this affidavit. I'll put this all in record. Lordship will consider. And my lord, if ECI is also filing their report, my lord, I'll take a short affidavit to that also.
But they just have to consider what were the documents on basis of which the voter card was issued.
Could the
Yes.
reports be also circulated to my client?
Yes.
Petitions and the private respondents are liberty to file reply if any.
Dana.
Yes.
My lord, it is also at page 98. My lord, the SIR also, my lord, the mother of the so-called husband's name has came at page 98 of my 90 of my writ petition. I stand corrected. My lord, let Ms. Pandey file the report. My lord, I'll take a short affidavit against, but maybe not against.
Counsel for the
regard to
petitioner
that.
submit that.
My lord will also give us also liberty to buttress our contention with the further report.
Counsel for the petition submit that the FRRO has filed report, but ECI has not filed report. And counsel appearing for the ECI prays for a week time to file report. Counsel for the petition submit that file report. In view of the above, the ECI is directed to file report within a week after serving the copy to the land counsel for the petitioner. The petitioner is directed to take if the petitioner is intending to file exception to the report of the FRRO as well as the ECI, the same shall be filed within a week thereafter after serving the copy to the learned counsel for the respondents as well as the private respondent. Let the matter appear on 8th September.
8th September. My lord, it should, my lord, retain the
within 5-10 matters.
Yes.
My lord, my client should also be related to.
The ECI as well as FRRO are also directed to serve the copy of the report to the private respondents, and private respondents also at liberty to take exception to the report if any.
I'm grateful.
I'm grateful.
Grateful to your lordship.
Yes, next.
My application, my lord. Your lordship will permit me to address your lordship virtually today.
Yes.
Sir, Mr. Agarwal, is the respondents appearing?
Yes, sir, they are appearing.
Very good. Well, the issue is very, very short here.
I have sent for the instructions that for what reason, my lord, he has been blacklisted and whether the proper procedure has been followed or not while blacklisting him. My lord, kindly keep it on Monday, my lord, and let me take instruction.
Want to take instruction?
Yes.
Come on, Monday.
Well, then let them not take any steps with regard to the blacklisting.
That has already been
blacklisting already done.
Yes.
Yes, blacklisting already done without any show cause, no hearing, nothing.
I said
That's
let
why
me
we
take
Monday,
instruction.
come on Monday.
My lord, may I only point out only one thing. My lord,
You are appearing
there's
for
a-
whom?
my lord, I am assisting Mr. Banerjee, my lord. There's an order of 10th July with the same direction to take instructions.
Right, do it.
My lord, we are
positively,
5
my
weeks
lord.
down the line, my lord.
Okay, come on Monday.
My lord, this matter may kindly retain its. My lord, blacklisted, my lord, I have been blacklisted.
Land counsel appearing for the state press for time to take instruction. Counsel for the petition submitted the matter was listed on 7th or 10th of July 2026. On the said date also the respondents have taken time for taking instruction. For the interest of justice, case is adjourned. Let the matter appear on 25th of August 2026 under the same heading within 10 matters.
Very grateful.
Next.
My application, my lord. But please, your lordship, my lord, I am appearing on behalf of the respondent bank.
Yes,
Lord, my application.
yes.
Lord, non-action by the part of the respondent bank. So in short, my lord, before I take you to the documents, my lord, I tell you, my lord, so-called notice was issued against my client for the my lord declaring me as fraud under the master circular of the RBI. But I was called upon to give a reply to so-called notice. Given, they were not satisfied. This is not satisfactory, and I give a further reply, my lord. Then in that, against that my letter, they have given, my lord, the letter, my lord, relying on 13 documents, that these are the documents which prima facie proves that there is a default and your account should be declared as a fraud. Now, I requested them to supply those 14 documents. They, by their letter, covering letter, had delivered 6 documents, but the 8 they have not. They have not delivered the balance documents.
So what is the case?
I am speaking, my lord. The documents should be delivered to me so that I can give a reply.
In the so-called reply, have you demanded any document?
My lord, my lord.
Where is the reply to the? Where is the so-called notice?
Kindly, my lord. Kindly come to page 90.
You have been declared fraud.
No. I'm not very kind enough to for them. They have not declared me fraud, but they have supplied the document. Kindly see, my lord,
two letters. I have next.
Where is the so-called notice?
So page 19, my lord.
Page 19.
My lord. This so-called, my lord, I am it's against director, not against the company. I am the, my lord,
against the director.
Yes, only director. The company, I don't know what happened to the company because I am no more a director of the company. So-called notice before classifying the account as a borrower as a fraud. This is the name of the company, Concost Holding Hong Kong Limited, and the reasons are there in the bottom. But against this so-called notice, I have given a reply at page 21. And that they found inadequate, and then kindly see the letter of letter dated page 26. This is reply to my representation dated so and so. We are in receipt of your representation dated so and so, respectively. In response to our so-called notice dated so and so regarding the LC facilities availed by Concost Holding Hong Kong Limited, we have gone through your representation, and the contents of your representation have been carefully examined. Upon detailed examination of your submissions and correlations with the documentary record available with the bank, your claim are found to be factually incorrect, inconsistent with documents executed by you, and legally untenable. You have attempted to portray yourself as a mere employee without having any role of responsibility in the LC operation. However, the Concost Group owns official management documents identified you as a group CFO responsible for the finance, banking, accounts, and commercial operations of the entire group. Furthermore, the independent done and broadcast report dated so and so for Concost Hong Kong Limited identifies you as a director, and at one stage you were 100% shareholder of the company. This independent verification clearly establishes that you held managerial ownership and decision-making authority within the borrower's entitlement. In addition to this, by two corporate resolutions, you were unequivocally vested with full authority to execute any other document apart from the letter of guarantee. The board resolution of the company dated so and so, signed by you, authorizes any one director to execute and deliver all documents required by for the LC facility letters issued by Canara Bank Hong Kong. Similarly, board resolutions dated after so and so dated expressly empowers you to execute any document.
Who is appearing for the bank?
Not for the bank, not for the bank.
So kindly come to the page 26, paragraph 2. This independent verification, where is the independent verification report supplied?
Millard, that was supplied, Millard, and from the...
Where is that the independent verification report is supplied to the petitioner?
Kindly come to page 36, Millard.
Yes.
Millard, at page 37, the bottom of the page, Millard. Millard, a copy of the Dun and Bradstreet DNB report, Millard, dated 31/7/2012, Millard. And the other documents have been supplied, Millard. Admittedly, these documents have been supplied.
You have considered in view of the representative, examined the detail and found uncertificated divide and merit as per the requested by providing the copies of the copy of the done
these documents
supplied. Then
now, Millard, the issue is, Millard, we have supplied this document. They have not said why these documents are not applicable or why these documents are bad in law. They have not said that, Millard.
Yes,
Neither they have annexed those documents in this writ petition.
Yes. Kindly see page 39, my lord. My letter.
Page
39. My letter, my lord, of the 21st April. Here, my lord, kindly see paragraph 2. In my representation dated so and so, I had specifically demanded supply of the following documents, all of which are material to fraud classification against me.
Yes.
These are the documents. Now, kindly see paragraph 3. Bank in reply has supplied only 6 documents, namely so and so. A bank has not supplied the following critical documents that were specifically demanded. Now, my lord, Concost Group, these the documents bank has not supplied. Now, kindly see, my lord, the last letter, page 43.
Whether the forensic audit report was conducted?
No, yes, and copy not given to me.
Forensic
That
audit?
conducted, my
Then where is the
Copy
forensic?
not given to me.
lord. I have the copy, my lord.
Then
My lord, I believe, my lord, that also has been supplied. What
show
is the
me,
case of the?
because
what is-
kindly come to the page 40, paragraph 3.
My lord,
The contest group internal management document
my lord.
and the forensic audit report, internal investigation
Malo.
report, if any, prepared by the bank, minutes of the fraud identification committee, that is okay. The complete LC document and the LC which you relied upon.
Malo.
Have you supplied to that?
My lord, for that, my lord, I require instruction.
Come.
2-3 days, my lord.
Let no action be taken, my lord, further, my lord,
The,
till they supply.
the grievance of the petitioner in the present writ application that the bank, in spite of several requests made by the petitioner, the bank has not supplied the document as mentioned in paragraph 3 of the reply dated 21st of April 2026, being annexer P8 of the present date application. Learned counsel for the respondent bank prays for time to take instruction whether the said document were supplied to the petitioner or not. Accordingly, case is adjourned. Let the matter appear on 26th August 2026. Yes.
Much obliged.
My lord, no further action will be taken in the, my lord.
It is pending how they can take. Yes, next.
May I find my affidavit service, my lord? Affidavit service.
Yes.
This matter relates to, my lord, the reservation of physically disabled persons. On the last occasion, my junior had argued the matter, and Lordship was kind enough directing the state to take instruction.
Yes.
What is to be done?
AG is coming.
My lord, AG is coming. AG sir is coming. Kindly. He is there at the court number 1, my lord.
Oh, no, whether the matter
time or
Yes, my lord.
whether
Yes, my
the
lord. I am
matter will be
praying
taken
for
up
a
by-
Passover, my lord.
so
cannot be passed over.
the fixed matter.
I can understand, my lord.
Tomorrow?
Tomorrow I don't
It's a serious matter.
because it has to be, you have to give answer. It is only the AG has to give the answer with regard to this notification.
The statutory reservation has to be followed. They have to reorient the roster. Anyway, let the AG land AG come.
Okay, pass. So
Grateful, my lord.
Not today.
not today. When I don't know time when the time will fix. Because my schedule is
I know it's a difficulty, but he's. ঠিক আছে পাশে থাক বেশি আসে তুমি থাকো
because if I will get the time, then it will go to September.
Oh, no. The people are suffering.
Okay, let it pass over. If it will come within 10-15 minutes, I will take. Otherwise, then we'll see.
Yes, sure.
My lord. Grateful, my lord.
This is my petition. Last occasion, on 1st August, Lordship has directed the bank. My account is defreezed, is freezed. I am seeking for defreezing of the account.
Who is appearing for the bank?
My lord, I am appearing, my lord.
Where is the report?
My lord, I am filing my report, my lord. I have already served a copy on my I land. have received from There the is no exception to this set of years. page number 3. The two amounts are disputed. Page 3, Roman clause B.
Page 3.
Page 3, second para. In or about 17th August. Such and such. Yes.
Karnataka.
Yes, Lordship. And the
inform the
disputed
bank
amount,
about the cyber fraud of sensations of 57,800.
yes. Another amount is, my lord, 5,500 is the disputed amount.
As per the contents and notice, they have highlighted the INR 5,500. No, what? Earlier 57,800. Such
Yes.
complaint was registered and acknowledged. As per the contents of the said notice, they have highlighted the INR 5,500 as disputed amount. Similarly, on 3rd June, this so.
Yes.
So 13,000. What is the total amount?
My lord, as my lord can see,
The cryptic order.
My lord will see the notice that, my lord, I can only submit what is on record. My lord kindly sees the notices that I have received. They are at page 53. My lord will see, my lord, one transaction ID UTR number is given. That is the notice that I have received from the authorities.
53.
Yes, my lord. Two notices received from places in Karnataka.
53. It has been sent by whom?
Yes, my lord, my lord sees police sub-inspector, this is district station, Karnataka, Chikkaballapur.
Correct.
Yes. Now, if my lord sees the transaction ID, see certain in the first table, my lord. There are two tables. If my lord sees the first table, my lord.
Tier 1.
Yes, the one above, my lord.
Tier 1 is the 5,500.
Yes, my lord. 5,500 transaction.
Correct.
If my lord comes to page 40.
That is on 3rd June 2024.
Yes.
Correct.
Yes.
Complaint dated 17 June 2024 at 16:12 hours.
Yes,
at
my lord.
Karnataka. Bank of Baroda. Yeah. Then
Yes, my lord. My lord, if my lord kindly takes, my lord, page 47 of the report once, I have annexed the bank statements, my lord. My lord will see that the number that is mentioned, the UPI number, and the amount will match. It's a credit, and thereafter there is
which clause? Which clause?
Page 47. If your lord sees.
Yes.
My lord. Arjun, there's a number 8724. That will match the number in the notice as well. The transaction ID UTR number given in the notice.
It's 47. Number where from you are reading the number?
Fourth number.
415577228724.
Yes.
5,500.
Yes.
Correct.
And my lord, my lord kindly sees the debit right afterwards. On again, see there's a number which is given.
Where?
Yes, 45.
Which page?
Same page, 47, same page, just the entry right below. The entry right below. 4546 3008.
Yes. Debit.
Debit 5500. Now, my lord kindly correlates this with.
Okay. Then
yes.
As per that, 3rd June 2024 at about 13:51 hours, the amount was credited. Correct?
Yes.
And 3rd June at 13:54 hours, 3rd June it was debited.
Yes.
Correct.
Yes. And if my lord kindly takes thereafter at page 54, the notice thereafter at page 54, my lord will see another transaction of 40. It's up to
page
50, page 40, page 54.
Yes, 4,200.
Yes, 4,000.
19,100.
Yes.
Yes.
And my lord kindly read this bank statement at page 47.
Yes.
And if my lord please
okay, no problem. So
yes.
So this is 5,500 and 4,200 and 9,100.
Yes.
These are the three amounts.
Yes.
These are the three amounts.
13,300 and 5,500. Yes. And my lord only.
So if it is so.
Yes.
So then what about this? We have stated 57,800. No, page 3, B, paragraph 2.
That is a loan amount, Muller. That's
So,
the loan amount.
Through UPI for online loan of.
They were seeking loan of amount 57,000.
February informed the officer about cyber fraud committed through UPI for online loan purpose of rupees. Who?
My lord kindly sees the complaint additional info, my lord, at page 53. Kindly sees, takes page 53, my lord.
Correct.
Kindly sees complaint additional info below the table, my lord. Caller informed that amount fraud through UPI for online loan purpose, rupees 57,800, amount has been fraud. So this is what is.
Where?
My lord, page 53, my lord, right below email, my lord. If my lord sees the entries on the top of the page, acknowledgement number is that email, after which there's a line, my lord, thereafter
Caller
complaint.
informed that amount fraud through UPI for online loan purpose, 57,800 amount has been fraud.
Yes.
So the out of the 57, this is the three amounts.
These are the three amounts.
These
are the three amounts which are disputed. Now, my lord, I have my lord kindly takes the account status. I am told that the account is currently dormant. That is what has been given in the report also. Account status is dormant.
I cannot
During the
operate
freeze account, how you can make the dormant?
My lord, that is the
So
that is what I am submitting before your lordship. That is what I am submitting before your lordship. That
when the account was freezed in 17 June.
2024, my lord. That would be in 2024, my lord. In 2024.
When the account was freezed. When the account was freezed.
My lord, action taken date. There is possibly, my lord, an action taken date. My lord, takes page 53 and 54. Again, I'm taking, my lord, again to those pages, my lord.
17 June.
Yes, my lord. 17th June 2024, my lord.
2024, the bank, the account was freezed.
Yes, two dates, my lord, are there. My lord, one at page 53, one at page 54. 17th June, and thereafter at page 54, it's 3rd June. 3rd June.
First is the 3rd June.
Yes.
But the transaction is 17 June or 3rd June. So,
and my lord, one more.
Come on down, dormant.
One more, my lord, that I have to take instruction, my lord, because my lord, 2024, because 2026, this it has been filed, my lord.
Something else. Freezer is something else. If this court will allow to defreeze, but the account is dormant, then bank has to take up the petition. The account holder has to take appropriate steps for dormant account to the regular account.
My lord, there is one more issue, my lord. The police authorities have not been made parties, my lord, to the instant rate petition.
No information who is the
You do one thing. In the meantime, you made a police authority as a party.
One more issue is that I am not able to reopen any account in any of
dormant
Any other bank.
Why?
Any other? It has been uploaded in the online. Uploaded in the online.
Yes.
Yes.
Okay, so you do one thing. You made the police authority as a party. What is the address?
My lord, any order from the police authority.
My lord,
No, because it has
Actual records, my lord, from which police station it has been done. The notices, my lord, record from which police station from which police station it has been done, my lord. Pages 53 and 54, my lord.
So where is the
Yes, my lord.
address?
State District Police Station, Karnataka, Chikkaballapura, Diburahalli.
Yes.
Yes.
So you made this party today itself. You made and served the notice, and I am fixing after 10 days. And file the affidavit of service. If they will not come, then I pass. The bank has filed the report, wherein the bank has clarified that the bank has freezed the account of the petitioner on receipt of the report from the Karnataka Chikkaballapura Diburahalli police station with regard to certain transaction on 3rd of June 2026 and 17th of June 2026. The counsel for the respondent further submit that the account of the petition is also at the dormant stage. Is as dormant. The counsel for the respondent raise objections and submit that the petition has not made the investigating agency as party to the presented application. In view of the above, the petitioner is given liberty to add the Karnataka Chikkaballapura Devali police station as party respondent in the criminal case in course of the day and to serve notice upon the investigating to the added respondent. The investigating agency is directed to file report by the next date fixed. It is further made clear that on the date fixed, if the investigating agency will not file report, the appropriate order will be passed. In the meantime, the bank is also directed to appraise before this court once the bank has freezed the account of the petitioner, how the account has been kept in dormant. Let the matter appear on 28 August 2026.
Can we, in the meantime, can we operate our direction upon the RBI to allow me to open any bank account?
Any other bank?
Any other?
Come on that day, I will see to that. I will dispose.
My lord, one more issue, if my lord kindly notes, my lord, 2024, my lord, this was done. Apparently, 2026, the writ petition has been filed.
That's correct, but why
Some delay.
why the yes RBI? You are why the bank, the other bank is not allowing to open the bank account?
From the last one.
Yes, you made a complaint in the meeting. You made the complaint.
My lord has taken the report on record. My lord has taken the gratefully, lord.
होता बोल ही देना report filed by item.
Next will the similar issue. Report has been filed.
I appear for the bank in this matter.
Yes.
We have filed a report that pursuant to an online complaint
Ah.
from the cyber alert department from the police station at Chennai, my lord, this account has been marked as debit freeze. I have an HD document. Your lordship. The bank has no objection to lift the debit freeze, my lord, but
Who has made a complaint?
my lord, kindly come to page 10 of my report.
Where is the report?
Tender my apology, my lord. The original copy is with me. Kindly come.
Yes.
4 para 6.
1,000 rupees.
Yes.
Your lordship, there
And the total account has been freeze. Wow.
Your lordship, there is, as per the master direction of RBI, my lord, to monitor the accounts where the fraudulent.
Which master direction you are asking upon?
I have referred to that, my lord, pursuant to that.
Which master account?
Kindly come to page number 4. That master direction has.
Date. Date.
Yes, your lordship. Kindly give me a moment. Yes, 6th March 2025, my lord.
6 March 2025. April 2026, there is an SOP?
Issued by the Ministry of.
Yes. April 2026, though it has been published in January 2026, but it's come into effect on April 2026, and there is a new SOP with regard to this type of the crime. The bank only can freeze the account with regard to the disputed amount, and that too you can keep the same unless and until no review has been given by the investigating agency for the 3 months.
Still, lordship, bank has no.
No, I am telling your bank is not updated SOP, and the SOP is not a small one. SOP is like big one. RBI is sitting behind me.
Lordship, I will go through that. Kindly, bank has no objection. Kindly pass the necessary directions pursuant to this.
The petitioner has filed the present writ application praying for an order directing the respondent bank to defreeze the account of the petitioner, being account number 75034166699. Which current account or saving account? Being saving account. The counsel for the petitioner submitted the petition is maintaining said account in the bank, but all of a sudden the bank has freezed the account of the petitioner without any intimation and without any information to the petitioner. The petitioner has requested the bank, but the bank has not informed the petitioner with regard to the reason for which the bank has freezed the account of the petitioner. The bank has submitted the report wherein submitted report and submit that the bank has freezed the account of the petitioner on receipt of the complaint. Complaint from whom?
The complaint has been lodged at the portal, my lord, of cyber fraud.
Complaint.
If my lord comes to page 10, my lord, the concerned police station is
on receipt of the online cyber complaint.
NCR.
Online cyber complaint, wherein it is revealed that the disputed the transaction amount is ₹1,000, and as such on receipt of the said complaint, the bank has freezed the account. Then counsel appearing for the bank submit that the bank has no objection if this court pass an order for defreezing the account of the petitioner, as the bank has not received any further communication from the cyber crime authority with regard to any further investigation, or the account is further required for investigation. But the land council for the respective parties produce the matters on record. This could find that the disputed transaction amount is rupees 1,000 only. And the complaint was and the account was freezed by the bank on 30th April 2026. Within 4 months, the investigating officer has not made any further correspondence with the bank. Next. Bank. Considering the above, this court find that the only disputed amount is rupees 1,000, and no further correspondence has been made by the investigating agency with the petitioner. Accordingly, the bank is directed to allow the petitioner to operate the bank account by keeping the disputed amount of rupees 1,000 in lien. Great. Disposed of. Next.
Item number 148, my lord.
Yes.
In which, my lord, I was led by learned advocate general.
Ah.
My lord, my learned advocate general is stuck in court number 1, my lord, is arguing, and that matter will go, which is with regard to the.
Where is Mr. Bhattacharya? Yes.
Only difficulty cannot oppose, my lord, on the ground. Only difficulty is on the basis of that rosters. Recruitment are being conducted naturally. My lord, we cannot participate. If your lordship any day, subject to your lordship's convenience, any time may be fixed so that the matter can be. My lord, your lordship is hugely burdened any day, my lord, subject to your lordship's convenience. And time may be fixed because this matter is being heard on a fixed time.
और एक दो डेट दे और एक है एक अगस्त खाली है 1 सितंबर though the matter is special fixed today at 12 noon for hearing, but due to some personal difficulties, the learned advocate general is busy in the other court. According case is adjourned. Let the matter appear on 31st of August 2026 and 1st of September 2026 at 12 noon as a specially fixed matter.
31st August.
31st and 1st because the matter is to be disposed.
Both the days. Great.
Yes, next.
My lord, item number 13, I am appearing for the petition.
My lord, I am appearing on behalf of the State Bank of India. My lord, State Bank of India.
On the last occasion, your lordship had heard this matter. This relates to the freezing.
Respondent 3451, respondent directed to.
I have served the
My lord,
respondents. My lord, this is my affidavit of service.
File the report regarding.
My lord,
the freezing.
earlier occasion, my lord, State Bank non appeared on behalf of the State Bank of India. My lord, recently I have been engaged on behalf of the State Bank of India. Respondent of file. My humble submission to lordship kindly extend 10 days time. I will file a report, my lord. Just now I have been engaged, my lord.
Yes, come with the
10 days time, my lord. Just.
Are you? My lord, let it retain its position at. Only like DFC Bank. And
you are appearing for?
I am appearing on behalf of the State Bank of India, respondent number 5.
5. And
Yes.
you for 3?
Yes.
HDFC?
Yes, yes.
And what about the 4?
3,000.
Baroda? Bank of Baroda? You are appearing?
I have filed the report, my lord, but it was affirmed in time, my lord. But due to some miscommunication, the report has not been served upon the parties.
How do you serve it?
I'm filing.
Served and give the copy here. Respondent number 4 has filed the report after filing today.
Yes, my lord.
Ready?
The direction from the.
No,
Not ready. Learned counsel appearing for the respondent number 3, 4, and 5. Praise for time to file report. Praise for extension of time to file report. Let the report be filed within 10 days after serving the copy to the learned counsel for the petitioner. The petitioner is liberty to take exception to the report, if any, within a week. Within a week. List the matter on 3rd September under the same heading within 10 matters. Affidavit of service supervisor. Kept with the range. Next.
14, 15, and 16.
14, 15, 16.
May it please your lordship.
Yes.
Bank of Baroda is supposed to appear.
Huh?
Bank of Baroda is supposed to appear.
Yes, Bank of Baroda, Dipanjan. You are appearing.
My lord,
No,
mistakenly,
Today they were supposed to submit the cost benefit analysis report.
Report be filed by 30. After serving the copy, then
No report,
you have to take action.
nothing has been served to us.
No report filed.
No, nothing has been.
So,
Yes.
you are filing.
What are the reports?
Yes. Separate report আছে.
What are reports? Well, Lord, just see the report, the breakup of calculation, why they have deducted the amount, that must be specified. This is a plain report in the form of an affidavit explaining something. I don't know what is this explaining. See the page of the report, Annexure A, report on behalf of the bank. What is our present balance, on what basis they have deducted the amount? Whether they were having losses on MDR or not, that must be explained. It cannot be a vague report like this.
Yes, madam. What is this? Have you gone through the report? What is the reason? You have not mentioned the reason. What is the reason?
And the calculation.
Where is the calculation? Is not here.
Calculation is not there.
Calculation not here. At the time of onboarding the merchant facilities, the merchants had presented and committed that they would maintain the minimum average of 30 crore. Correct. That the expected maximum transaction limit would be 1,100 crore. On the basis of the commitment, the discounted MDR charges to them. Accordingly, the merchants were enjoying the MDR at the concessional rate of 9%, 0.90%. And the cost incurred by the bank towards the transaction is 2.70%. Then, half-yearly review MDR conducted by the bank is observed that the merchant has failed to maintain the commitment minimum 30 crore. It was further observed that the transaction volume exceeded the, okay. Upon noticing the, where is the details?
Where is
the details? Because your condition that they will average 30 crore. Minimum average they will maintain 30 crore and they will spend 100 expected transaction will be 100 crore. But they have not maintained the 30 crore and they have utilized more than the maximum level 100 crore. Then what has happened?
my lord, kindly fix the matter subject to your lordship. My lord, Mr. Dotto has been engaged in another court, my lord.
To the failure of the merchant comply the commitment. So where is the agreement? What is the agreement?
Agreement is there in the supplementary affidavit.
Where is the agreement? If it supplementary affidavit of the petitioner.
Yes, your lord.
Where is the agreement? If there is an agreement that he will not maintain the amount, then he will freeze the account.
Nothing was mentioned in the.
If it is not, then you have to take appropriate steps. How you can freeze the account?
Page 5 of supplementary affidavit.
Where is the supplementary affidavit?
That is correct.
No supplementary is here.
Lordship, we have not received any supplement.
No,
Huh?
we have served it.
We have not received.
We have served it already.
Copy দিয়েছিস? Copy দিয়েছিস?
Yes, Mr. Datto.
My lord, I find from the records.
They are not maintained the 30 crore.
Yes.
They are
Exceeded
the 100 crore.
Or even within 1 month, they were supposed to maintain that for 1 day, or for 1 year. they have exceeded that limit in 1 month, which is
Good
contrary.
merchant.
No, my lord,
Suppose
they,
Yes, yes.
well, the problem is, once they exceed that amount, we have to pay that exchange value. The last day, if your lordship kindly recollects, that the exchange value or the
2.70.
yes, the
And they are, you are getting only 9,
yes,
0.90.
the effect becomes that the ratio at
No, that's correct. But how, where is the provision for freezing, or you take steps? Why is the freezing?
because for recovery, because
This is not the way of.
Recovery, you can take the amount. How the freeze?
yes, I understand.
Where is the agreement?
Agreement I have
One more thing,
indicated.
they are saying they are incurring loss on MDR charge.
Yes.
Correct.
MDR charges means merchant discounted. What is basic? My lord, when was my lord was sitting in original side commercial division, in one of our matter told us that you acted as mediator for banks. So my lord very well knows that it is almost akin to a middleman charge. If we are earning the amount of profits that they are alleging, then it should serve more good to them than any harm.
No, that's
It
correct.
cannot be.
That's correct. But how this freeze?
Understand?
You have to take steps. How the freezing can be done?
And for lien, they have to keep the bank.
Bankers lien, we have exercised that, but
That cannot be the initial stage. Initial stage can be. Can't be.
Wrongly exercised. They cannot put entire amount to
but
lien.
kindly gives us the liberty to exercise our options for recovery of the
You
charges.
take appropriate steps in accordance with law, but I am allowing to directing to defreeze this.
Well, only that, because
If you have any grievance against the petitioner, you not.
we have already issued the demand notices.
Yes.
We have already.
Appropriate steps in accordance.
No, not
এই দিয়েছি বাবা, এই দিয়েছি বাবা, দিয়েছি।
দেখো
হ্যাঁ দিয়েছি তো,
না দিয়েছো বলে
এই রিপোর্টেই বলেছি। ওরে দেখ, এখানে দেখ, এখানে অ্যানেক্স করেছে তো বোধহয়।
আজকে দিলে
না না,
আজকে দিলে কোথায় দিয়েছো দেখো।
আরে মেল করেছে তোদের। এই দেখে দেখ, এই দেখ।
The petitioner has filed.
এই দেখ।
What?
না না।
What they
Not morning in the 3:20 AM.
What they are, my lord, kindly read what they are claiming as demand.
Where is the on your notice?
এইটা তো page 23.
Which one?
Page number 20.
Which one?
Of the main application. Petition number 28634.
Okay, whatever it may be, you take is you reply and they will take appropriate.
Kindly,
Page
23. Kindly read. They are calling this a demand notice. This is that damage done and something done to damage control.
It is in 2025, not now.
Whatever that is. It is first we will cut off your neck, then we will say sorry.
No, first this notice was given, then the
petitioner has filed the present date application praying for a direction upon the respondent bank.
Subject to my
bank.
May I take your lordship?
Bank to immediate to provide the breakup of how the respondent bank arrived at the calculation of rupees 1. Breakup of the deduction, how the respondent bank has arrived at the calculation of rupees 1,41,30,875.19 rupees, and also prayed for a direction for decreasing. For where is that? There is no prayer. There's no prayer. There is no prayer for decreasing.
Yes, your lordship.
Where is that?
First prayer. With respect to the prayer.
And for decreasing the accounts of the petitioner and to lift the lien mark of the account of the petitioner. The petitioner submit that the petitioner is maintaining when you obtain this, which date you obtain this amount?
Which amount, my lord?
When you come to the agreement with the bank with regard to maintaining this amount and the
Supplementary affidavit.
there's nothing.
This is as per the agreement, it is January 2025. No such specification.
There's no specification.
No such specification has been mentioned in that agreement.
How you are drafting the writ petition? Thing is there. The petitioner क्या बोला ऊपर last में क्या बोला? Maintaining the current account number 3221020000510 536 with the Bank of Baroda. We give Bank of Baroda. Full stop. He submitted that in the month of January 2025, the bank has arbitrarily freeze the account of the petitioner without assigning any reason. Without assigning any reason. He submits that the respondent had deducted the huge amount of money to the tune of rupees 1,41,30,875 as MDR charges without giving any breakup to the petitioners as on 29th of August 2025 and frozen the amount of rupees 8,79,406 lying in the said account. This court has called for the report from the bank and bank has submitted the report. In the report, it is mentioned that at the time of onboarding of the merchant facilities, the petitioner has represented represented the bank that he will maintain the minimum average balance of rupees 30 crores with the bank and the expected maximum transaction limit would not exceed rupees 100 crore. It is further case of the respondent bank that since February 2025, the petitioners were enjoying MDR charges at the concessional rate of 0.90%, whereas the cost incurred by the bank towards the transaction was approximately 2.70%. He submitted that during the half-yearly review of the MDR charges conducted by the bank, it was observed that the petitioner has failed to maintain and committed the minimum average balance of rupees 30 crore as assured by the petitioner in their account. And it was further observed that the bank the petitioner has exceeded the expected maximum limit of rupees 100 crore. And accordingly, the bank has freezed the account.
Which was not mentioned anywhere or communicated. Which was not mentioned anywhere in the agreement, neither it was communicated.
Learned counsel for the petitioner submit that the bank has arbitrarily freeze the account on the above mentioned allegation as there is no agreement with the petitioner and the bank that if the petitioner exceeds the expected minimum limit and will not keep the balance amount of rupees 30 crore as agreed by the petitioner, the bank will freeze the account of the petitioner. Had the learned counsel for the petitioner produce the matters on record. Admittedly, there is no condition in the agreement that the bank can freeze the account of the petitioner if the petitioner will not maintain will not keep the minimum average balance of rupees 30 crore or will transact and will exceed the expected minimum limit of rupees 100 crore. Land Council for the bank, it is found from the record that the bank has also issued a notice, though, but in the said notice, there is no such clarification has been made. Considering the above, this court find that the act of the bank by freezing the account of the petitioner for the above said alleged allegation is contrary to the law, and there is no condition in the agreement. Accordingly, the bank is directed to immediately defreeze the account of the petitioner and to allow the petitioner to
And my lord, remove the lien mark. Remove the lien mark and make the account function.
Lien of the amount of rupees 8 lakh.
8 lakhs is in one, another is 32 lakh.
You have mentioned only 8 lakh here.
No, it is in one of the read petitions.
To lien free the account of the petitioner, to lien free the account of the petitioner, to petition and to allow the petitioner to. No, but your prayer is a defreezing. Kindly come to prayer.
Prayer is defreezing in one of the requests. And the amount is varying.
The defreezing is different. Yes, indicated then. The bank is directed to immediately defreeze the account of the petitioner and to allow the petitioner to operate the bank account by lifting the lien mark over the bank account of the petitioner. Police. It is further made clear that though this court has allowed the bank and directed the bank to defreeze and to lien free the mark of the account of the petitioner, but the bank is at liberty to take appropriate steps against the petitioner in accordance with it.
My lord, one last point. Hope it is not an innocuous prayer. In the read petition number 10779, the last read petition, this bank account was in our Shambazar branch. And the other two were in Salt Lake Netaji Nagar branch, Netaji Subhash Road branch.
Amount are the same.
No. But the decision which we have challenged in the first two read petitions, that was applied retrospectively. Even after that bank account was closed, and their authorities agreed that the bank account was closed. Still, they kept the POS terminal open. And
so, what do you want?
Return to Econina.
So in that case, you have not submitted the report. No. So that is this will come to the item number 14 and 15.
No, read petition
28634. That is the freezing. And 107779.
1077. Item number 17.
My lord, I am not there in item number 17.
You are not there.
No.
Not there.
16.
16. Item number 16.
Item number
16.
14, 15, 16. 16 is?
16 is cost title is Holiday Hub Private Limited.
I have submitted the report.
Yes, you have filed the report in all three matters.
Yes.
Then you're telling that you're saying.
I was saying for item number 17, I am not there.
17 now.
Submitted 14, 15, 16.
Yes, I have submitted the report.
But the 16 is also same. 14, I have passed the order.
14 and 15 are the same. 15? And that was
15 is 1079.
No.
15 107.
107. Number
Yes, 15 is different. Some are
two were analogous matter, one was homologous. The decision which we have challenged in the two read petitions, in the analogous read petitions, that was applied retrospectively.
So then 14 and 16 are the same.
14 and 16 are the same.
15 is different.
15 is different.
Come to the 16, the amount is same.
No, amount is different. Amount is different.
Then what is the amount in the 16?
I'm telling my lord.
75 lakh.
75 lakhs and lien mark is on the residue amount of 32 lakhs. Not.
But the report is same.
Report is same too. Report is.
So when I mentioned item number 16, in that case I mentioned 8 lakh. 16 would be different. No, 14 and 16 will same. 14 and 16 will be same. Okay, but amount in the 16, the amount will be 75 lakhs. I mentioned 8 lakhs, no? One crore 41 lakh, no? It will be 75 lakhs. 75 lakhs. Yes, what about this 17, 15?
15, what I have told just now, my lord, that in the 14 and petition number
14 and 16, same I disposed of.
Disposed of, that the decision which we have challenged in writ petitions number 14 and 16 has been retrospectively applied. And even after the bank account was closed in writ petition number 15, they have kept the POS terminal open. It is a procedural mishap on behalf of the bank.
So what you want?
1 crore 51 lakhs has been wrongly recovered. So, my lord,
1 crore 49 lakhs.
1 crore 49 lakhs.
Yeah.
Two of our petitions.
So,
three of our.
So, my lord, the freezing with respect to that
same
account.
order will be.
Same. Then great.
Only the third and the amount will be 1 crore 49 lakh 66,000. Amount will be changed. Correct. Because your POS is running, continuing. POS is continuing. So only this amount has been freezed.
Amount has been freezed.
By keeping the account on lien.
Yes.
This report filed by the bank be kept in the record. Yes, next.
17, I am for the petitioner, my lord.
I appear for respondent
My lord,
number 4.
will it be your lordship's pleasure to take up the matter tomorrow, my lord?
Why?
I misplaced the brief, my lord. To be very candid, my lord. I'll do it tomorrow, my lord.
Okay, not today.
I'm grateful, my lord.
Next.
18, my lord, I am appearing for the petitioner. My lord, this is the allegation against the respondent number 14 to 18. My lord, by constructing house by filling up the water body. That is the allegation. My lord, if your lordship kindly say the RS.
Have you served?
Yes, already
14 to 18?
report has been filed by the additional district magistrate. And against this report, I already filed the exception. And if your lordship kindly see for the report, my lord, in report, additional district magistrate also, my lord, classified the same as a pupur, and their respondent number 14 and
report
8.
is on record.
My lord,
no report is on record.
Report has already been served, and my lord, exception I already filed.
Report filed by?
Report filed by the additional district magistrate.
Additional district magistrate. Yeah, Bankura.
Yes, Makura. My lord, on that, my lord, this is the report, my lord.
Yes, it is there.
My lord, on.
Who is for the state?
My lord, state filed the report in earlier occasion also served. My lord,
That is prior to the change in panel, April.
No.
You do one thing, you give the copy to the learned advocate.
My lord, then I served, my lord, any of the advocate.
Give the copy and the report.
Yes, you give it to me.
Learned counsel for the petition is directed to serve the copy of the writ application and the report and the connected documents to the learned advocate appearing for the state in course of the day.
In course of the day.
In course of the day. Let the state is directed to take instruction. Let the matter appear on 8 September.
8 September, same position. Same position. Grateful.
Yes, next.
Pencil.
My lord, I am appearing for the state, my lord.
That matter where MSME, whether it has to be, the agreement has to be registered before or after. That was the question that was brought to your lordship's notice by Mr. Bhattacharya. The state had said they will be making their submissions
My
to
lord, I have just received the instruction. Though I have gone through the judgment in NBCC India Limited, the issue with regard to this has been referred to the larger bench. But, my lord, I find, my lord, that the point of maintainability of the writ petition is to be argued before your lordship.
No, but the question is that, okay, the point is kept before the special bench or the larger bench. So what would happen?
No, my lord, the point here is in this matter, my lord, so far as I have understood, my lord, that the conciliation proceedings have failed and the matter has been referred to the arbitration. Now, my lord, so far as the maintainability of the issue they are raising can be raised before the learned arbitrator also. Because under the Act, MSME Act, my lord, it has to be governed by the provisions of the Arbitration and Conciliation Act.
What is the point? Work order?
No,
yes,
yes,
work order
supplies.
which was
So
given
that is
to
the
the
point. Work order, how the arbitration referring to the arbitration?
MSME. It is not the work order. It is a
Oh,
supply.
that's why MSME under the work order.
No, not work order.
Lordship,
It is supply, not work order.
Lordship,
Supply of equipment.
Supply.
Yes. He was the supplier.
Kindly comes to the agreement that is at page 26.
Not work order. And my lord, I have
It
just
is a work order, Lordship. It clearly says at page 27.
supply of goods. He is a
Owner has
supplier.
placed work order to so and so for the supply, implementation,
Supply.
and maintenance of DMR tier-based trunk wireless communication systems.
Yes, owner has placed the work order so and so, so and so. That is the matter.
Supply, implementation, and maintenance, Lordship. There are three parts to the.
It is not simplicity work order.
Okay. Then when?
My lord, kindly day after tomorrow, my lord, I shall come back.
Sir, can I may I come in, sir? If you don't mind, sir, please. Can I put into my point of view, sir?
Yes.
Yes, sir. Sir, the 3 points of dispute that they have raised. The first point is that under section 19, it says no court shall appeal, accept, maintain a court of accept the appeal in a matter which is sent by decree, award, or any other order of the MSAB. Sir, they have gone to the they filed a writ petition on the basis of a notification by the MSME for arbitration since the conciliation meeting had failed. So that is point one, sir. The point two is their only dispute is that we were not registered as the MSME supplier on the date of contract, but subsequently we were. Sir, this matter has been cleared in the NBCC judgment, which I've copy I've given to you. Sir, there's no question of supplier. It is any party to the dispute can submit go to the MSME council. That is point two. Point three, they have said this matter is pending for reserved for judgment in the Supreme Court. Sir, the Supreme Court has made it in various judgments, which I can give it to you tomorrow. I could not come today. That no adjudication should stop in the absence of the final adjudication by the Supreme Court. So that is also there. Last but not least, sir, the Supreme Court in the matter of India Glyco judgment has said very clearly that a writ petition cannot be filed from any matter in the MSME judgment. They have sent back the matter back to the MSME.
Yes, madam. Yes,
the appeal.
The question is that whether the MSME is applicable. At that time, when the contract was awarded, there's no contract.
There was
no
MSME. What I have found from the documents, my lord, when the contract was originally work order was issued, my lord,
there was no.
It was not registered. But it got registered in the meantime, and the supplies were going
subsequently.
On. And my lord, it is not. It was a work order.
But the work order which has been issued not to the MSME. That
no,
is the
my lord. Thereafter, after it got registered as MSME, also, my lord, the supplies were being affected. Not only as a part of this work order, but further orders were being placed. So, my lord, whether it has to be interpreted that
is the only question.
And no, the question is, my lord, then I have found, my lord, that all supplies were made all after the registration being made. In fact, the orders were also placed subsequent thereto.
See,
that's not right.
If today the work order has been issued and today there is no MSME, correct? And pending, because he has to comply with the work orders, he has to execute the order, he was executing the order. In the meantime, MSME come into effect. So whether the agreement or the work order issued or entered between the parties prior to the MSME come into effect, whether the petitioner can be taken, as a MSME.
My instructions are, my lord, that even though a part of the work order has been issued prior to the registration as a MSME unit, my lord.
Not part. The total agreement was entered.
No, my lord.
Kindly come to the page 26. 22nd of March 2019. So 22nd March 2019. Agreement entered. Then, so subsequent work order in terms of the agreement.
In terms of the agreement, my lord, whether my instructions are that all these invoices were raised, my lord, supplies continued after the it got registered as
That's
MSME.
correct. Invoices has to be raised after the execution of the work.
And this same issue is pending before the larger bench.
No. This issue is not there. This issue
is there.
The issue with regard to the sending to the larger bench, whether the MSME council with respect of the work order can refer the matter to the arbitration. That is the question.
No,
but here the question is that if the agreement entered prior to the MSME and he was continuing, whether you can treat the person, the contractor, as a MSME. That is the question here.
I shall satisfy your lordship.
With regard to the full bench, that is a different question.
My lord, kindly at page paragraph 25 of the Supreme Court judgment, my lord.
Which MDCC?
NBCC. Lordship has the judgment, my lord.
Let me see.
Hand it over to you, lord. And my lord, there are other judgments also, my lord, which I would come with, and when the arbitration proceedings are there, jurisdiction issue can be taken up before the learned arbitrator under section 16.
The registration was done.
Yes, NBCC, which paragraph you are relying on?
Paragraph 24, bottom, my lord. Whether registration is a necessary precondition to referring a dispute under section 18 of the Act.
Page 24.
Paragraph 24, my lord.
Para 24.
My lord, your lordship has this print?
Yes.
It is in the bold. Your lordship has the SCC version, my lord.
No, online. Online.
No, it will not tell. No. It a print out SCC. Can I just find it out? Or your lord takes it a 10. No, my lord, can it be taken up day after tomorrow? And my lord, one more thing, my lord, your lordship's court is getting a little suffocated.
वही क्यों है ऐसी मुझे भी गर्म लग रहा है आपको ठंडा लग रहा है
Yeah,
I am also feeling
I'm telling
hot. Why? ऐसी क्यों कम कर दिया बंद कर दिया बढ़िया
Well, we are just not feeling comfortable.
Land counsel for the state press for time to argue the matter. According cases adjourned, let the matter appear on 25th August.
25th?
Yes, next.
Wait,
Yes, Mitra, what matter?
The next matter was by, but second half I am not there. My other side is Mr. Lakhwani just now saw.
Item number 20.
20. Number 20.
Okay, not today.
I'm
Come to not today. Yes, call the list.
Your Lordship, I am for the petitioner. The petitioner's name has already been included.
It is submitted by the petitioner that the petition name already been included in the voter list. Accordingly, writ petition become infectious. Accordingly, writ petition is dismissed as infectious. Yes, next.
Yes, Your Lordship, I'm appearing on behalf of the petition.
Lordship, I am for the state in this matter.
The appeal number is in place. Not South Chowbish Pradhan.
Page number
40. Page number, Your Lordship, page number 40. Annexure number 5.
Yes.
Yes, Your Lordship, in this matter also I'm representing my senior, Mr. Alokesh Dalal.
Page number. Tell him only page number.
Page number 38, Your Lordship.
Disposed of.
152, Your Lordship, in this matter also. Page number 36, Your Lordship.
Disposed of.
District.
Next.
I am in the petitioner. I have filed an application before the honorable
Page number.
Chip it. Short.
Sorry. Slow.
There, yeah.
He has not annexed the appeal copy.
Pick number whether it is appeal or before the authority. Disposed of. Yes, next.
My lord, 154, I am for the petitioner, my lord. The appeal page is at page 35. Here the petitioner is a government employee, my lord, who is in charge of her retirement, my lord. He is finding it difficult to process her pension papers.
When he is going to retire?
My lord, in January 2027.
It's copy. So many days are there. Yes,
So can
next.
it be, my lord?
Next. You filed the appeal?
Yes, Lord.
When? With page number?
29, Lord.
Disposed of. Next.
Lordship, page number 50.
Disposed of.
District of North Chowbish Pradhan.
Next.
Page number 15.
Disposed of.
Page number 20.
Disposed of.
Page number 18.
Disposed of.
Page number 18.
Disposed of.
161.
161. None appears. No accommodation. Dismissed. Next. 162.
Page number 17.
Disposed of.
Others.
How many persons?
163 কে আছে? পুরো ডিসমিস হবে। পুরো ওইগুলোকে ঢুকিয়ে দিই। হ্যাঁ।
It is find that altogether there are 17 petitioners have filed the present writ application. Accordingly, writ petition dismissed. However, the dismissal of the writ petition will not prevent the petitioners to take appropriate steps for filing separate applications. Yes, next.
164, page 37.
My lord, page number 35 for petitioner number 1 and petitioner number 2, page 37. My lord.
Disposed of.
165. Lordship, I seek the liberty to withdraw it with the liberty of your lordship to file it afresh.
As per the prayer made by the counsel by the petitioner given liberty to withdraw the writ application with the liberty to file a fresh.
Gratefully.
Next.
Lordship, page number 36.
Disposed of.
Scanned copy the reach.
My lord, I am petitioner.
Scanned copy.
I'm for the Indian area.
Disposed of.
I'm for the petitioner, page number 30.
Disposed of.
I'm for the petitioner, page number 33.
Disposed of.
My lord, 171, my lord, I'm for the petition, my lord. It is, my lord, husband and wife, my lord, page 39 and 41.
Disposed of.
I'm for the state in this matter, number 109.
Disposed of.
173 million, I am for the petition, my lord.
Page.
Page below 36.
Disposed of.
171, I am for the petition, my lord. Page 26.
Disposed of.
Others are checked. Kojun.
Blood,
How many persons are there?
Blood, I have deposited the blood.
How many persons?
The blood, 6.
Give. 174.
देखिए कत আছে দেখুন তো দেখি I have deposited, already deposited.
No, deposit will not solve the purpose.
Otherwise,
They are related.
Let it be regularized, lordship.
36.
It is the
Different people, your lordship.
They are the different people.
The
Nothing.
blood, lordship, kindly
Nothing
blood,
doing,
excuse.
nothing
Since I have already deposited deposit court fee, let it be the condone, Lord, for the 5 minutes. I have deposited it, Lord.
What can be done? They are not the relatives. They are the
But not the same villagers.
This court find that altogether 6 petitions are filed the presented application, but the cause of action, all the petitions are different according to dismissed. However, the dismissal of the petition
Both matters, your lordship. 173,
prevent
174.
the petition to take up a petition in accordance with.
I have deposited both the cases.
174, 175, both.
173, 174.
Yes, both same order.
173.
Yes, next.
I am for the petition, my lord. Page 33.
Disposed of.
33, appeal.
176, lordship, I am for the petitioner. Lordship, she is a FPS dealer, lordship. My appeal is at page 30. And my lord, this is the similar set of circumstances. My lord has passed an order, lordship. The similar set of circumstances.
What?
She is a FPS dealer, lordship. She has applied for
Puro full form बोलना है.
a place shop dealership, lordship. Lordship, and she has preferred an appeal, page 30, lordship.
Okay.
And my lord was pleased to, in a similar set of circumstances, my lord was pleased to pass an order.
You are running the FPS dealership, no?
No, she has applied. She has applied. She's yet to get the dealership, lordship.
The petitioner has applied for FPS dealership, but due to the deletion of the name of the petitioner from the voter list, the candidature of the petitioner is not considering by the respondent authority. He submitted the petitioner already prepared an appeal before the appellate tribunal and placed for disposal of the appeal as early as possible. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to dispose of the appeal prepared by the petitioner as early as possible, preferably within a period of 3 weeks from the date of receipt.
Deeply obliged, lordship.
Next.
177, my lord, page number 33.
Disposed of.
It is a disposed of matter. भूल को
Disposed of.
already it is disposed of
By this court.
by this court.
Delete. Next.
I'm for the petitioner, page 30.
Disposed of.
ज़्यादा scan copy दे दो.
180, I'm for the petitioner, my lord. Page 61 for the petitioner number 1, my lord. And page 63 for the petitioner number 2.
Who are they?
Brother,
disposed of.
181, I am for the petitioner, my lord. Page 29, my lord.
Disposed of.
182, again, I am for the petitioner, my lord. The page number 31.
Disposed of.
My lord, 4 petitioner, my lord.
All are relatives are checked.
My lord, wife, son and daughter. 4 petitioner, my lord.
Husband, wife, and children.
My lord, page 69 to 76.
Disposed of.
184, my lord, appeal, page number 26.
Disposed of.
28.
28.
Disposed of.
Page
28.
23.
Disposed of.
23. Page 23.
हाँ ठीक बात है.
Disposed of.
I'm for the petitioner, page 14.
Disposed of.
I am for the petitioner, lordship. Lordship, this matter is something different, your lordship.
Which one?
I am a
189.
189. I am a successful NEET UG candidate, your lordship, and my counsel already has been started. And now, at the time of counseling, the domicile certificate needed, and I applied to the SDO, and he's hesitant to give me the domicile certificate. My counseling already started, Your Lordship.
So what you want?
I want my domicile certificate, Your
This
Lordship.
court cannot issue the domicile certificate. How this court can?
Your lordship had passed
Your
orders
Lordship has
wherein,
passed.
your lordship had passed orders wherein the domicile certificate would be issued. However, post clearance of the voter card, it would be considered whether it was genuine or not.
The petitioner submitted the petition has cleared the NEET UG examination, and the counseling of the petition is going for getting admission in the MBBS course, but the respondent authorities are not providing the domicile certificate to the petitioner. As who are the petitioner? The same petitioner?
Yes.
Petitioner. So why the domicile? Because of the deletion of.
Because my name is written in SI.
Not considering domicile certificate, as the name of the petition has been deleted from the voter list. He submitted the petition, has already prepared an appeal before the appellate tribunal, and the same is pending before the appellate tribunal. He pressed for a direction upon the appellate tribunal to dispose of the appeal as early as possible. Until the disposal of the appeal, pending disposal of the appeal, the authority may be directed to issue the domicile certificate subject to the result of the appellate authority, appellate tribunal. In view of the submission made by the counsel for the petitioner, this court finds that the petitioner is the aspiring candidate for getting seat in the MBBS course, but due to the deletion of the name from the voter list, the authorities are not granting and not providing the domicile certificate. Accordingly, the authorities are directed to provide the domicile certificate on temporary basis with an undertaking by the petitioner that if the petitioner failed to success in the appeal preferred by the petitioner before the appellate tribunal, the petitioner will surrender the domicile certificate granted to the petitioner, and he will not claim the seat allotted to the petitioner on the basis of the domicile certificate.
My lord, item number
The
160.
appellate tribunal is directed to dispose of the appeal as early as possible, preferably within a period of 2 weeks from the date of receipt.
Due to extreme compelling circumstances, I'm constrained to travel your lordship.
My lord.
वो एडवोकेट का नाम था ना, क्या नाम है? दिया सर को नाम दिया लड़का? कौन था वो एडवोकेट? Who was that advocate? Who was that advocate? Who is the advocate? Shivam Bimsaria? Who is the advocate? Who has misbehaved with my officers here? You know, he was there after before recess. Who was that? Otherwise, tell anybody knows, tell them. Otherwise, I issue the so cause notice to this advocate. How he misbehaved with my officers. Shivam. Anybody knows this advocate? Let me see. Then I will issue the judicial order on this. I am taking all matters. I went and he started misbehaving with my officers. Yes, call the list. You are not sense. Anytime you mentioning, every day you are like this only. Every day. You are the only person who is having the only the urgent matters. So covered by the judgment, you come at the time when the mentioning is taken place. Counseling notice has been given 10 days before. All advocates are moving before this court, the counseling notice. So what has happened in the appeal? What you want? I don't want. So already date is fixed. Yes. Yes. So एक काज करो रखो कल कंटेम्प्ट एप्लीकेशन ऊपर करो उसको. Yes, call the list. Call the list. Number 21. What is your prayer? Who are you? Who are you? I am one of the members of the society. You are the one of the members of the. There are 4 members, 4 petitioners. What is the society name? Huh? Okay. Okay. So what is the prayer now? What is the representation? What is the AGM on 14 June? What was the AGM on 14 June? So your challenge that you not know. Kindly see the page 69 B. You are telling that they declare the AGM purported AGM 14 June 2016. So illegal. If you are not gone through the AGM, how you are telling you are asking for the? If it is not provided, so how you are praying for? Hmm. 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 Yes. Who? Hmm. 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 Yes, what is the content, sir? No, no. It's not disputed question of fact. If it is challenging the election, the registrar of society is the competent authority to decide the complaint. So let it decide. That's correct. What is the duty of the registrar of societies? Show me, show me, show me. Show me. Correct. You are challenging the AGM. What? What your challenge? Kindly see, read the section 23. Kindly read 23. Kindly read 23. Read. Creditor. Members. Yes. Hmm. Hmm. Correct. Hmm. Yes. 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 Okay, but 23, the government means what? Government is what I am telling. Show me the registrar's duty in the Societies Act. Other than the government, so registrar is other than the government. So, if a complaint has been given to the registrar, he can decide. Okay, if you're not able to decide, inform. Yes, I am not a competent authority. Go to the civil court. Why he kept tight over the matter? We are appearing for whom? Correct. That is okay. Kindly see, he is not asking. Kindly see the prayer. Maybe that is the authority with the court. The petitioner has filed the present writ application on with the grievance that the petitioner has made a detailed complaint to the Registrar of Firms and Societies on 18th of June 2026. But in spite of the receipt of the complaint, the Registrar of Society has not considered the representation and not disposed of the same till date. The counsel for the petition submit that the petition will be satisfied if this court direct the Registrar of Firms and Societies to consider the representation submitted complaint filed by the petition dated 18 June 2026 and after giving an opportunity to the petitioner to dispose of the said complaint in accordance. Land Council appearing for the state authority raised the objection of maintainability of the present date application and submit that the Council for the state. You are appearing for whom? You are appearing for private. Counsel for the private respondents raise objection with regard to the maintainability of the present writ application and submit that the writ application is not maintainable. He submit that the petitioner has challenged the AGM, which cannot be decided by this court, and if the petition agreed by the said annual general meeting of the society, the petitioner has to file a civil suit. He has relied upon the judgment in the case of Satya Prakash Ravidas versus Alka Niranjan Prasad Singha and others, reported in 2026 SEC Online Delhi 400, and submit that in the said case, the Honorable Delhi High Court, the Delhi High Court has categorically held that the dispute with regard to the election cannot be adjudicated in exercise of power. Dispute with regard to the societies cannot be adjudicated in exercise of power under Article 226 of the Constitution of India. Learned Counsel appearing for the state submit that if the petitioner has made a representation, if this court will pass appropriate order, the authority will consider and dispose of the same in accordance with law after giving an opportunity of hearing to the concerned parties. At the Learned Counsel for the respective parties, this court find that only the grievance of the petitioner that the petitioner has made a complaint to the Registrar of Homes and Societies on 18th of June 2026, making several allegations against the society, but till date the request made by the petitioner has not been considered. Accordingly, this court find that the petitioner the only grievance of the petitioner for disposal of the writ application not to decide the matter on merit. Thus, this court has not gone into the merit of the matter and has not gone into the merit of the matter. In view of the above, the writ petition is disposed of by directing the respondent number 2, to consider the complaint filed by the petition dated 18 June 2026, and after giving an opportunity of hearing to the petition and all the affected parties, if any, hearing to the petition as well as any other affected party, if any, and to pass a reason in its speaking order within a period of 6 weeks from the date of receipt of the 8 weeks. Okay. Yes, next. 8 weeks. Instruction will take about week. What is the matter? Protection of interest of the depositors under the Financial Establishment Act. Yes. Let it take instruction. Learned Counsel appearing for the state submits that and press for time to take instruction. According cases. For the affidavit of service filed by the petitioner be kept with the record. Learned Counsel for the state press for time to take instruction. According cases adjourned. Let the matter appear on 9th September. And next. Yes.
What number?
The added party had filed, I'm for the petitioner. The added party had filed an affidavit in opposition to our petition, to which I'll be seeking an extension to file the reply. But I'm ready with the reply of the other parties the opposition that they had filed, may I file the reply to that?
The reply of?
No, this is our reply of the petitioner.
Reply to?
No, the affidavit which was filed, in opposition by the respondent number 3.
Where is the affidavit in opposition?
Respondent number 3.
You are appearing for added.
Yes, my lord. My lord, the difficulty is there is some urgency in the matter, and that's why my lord would see that it has got that history that initially they obtained an interim order, later on added me a party, got me within the ambit of it. Be that as it may, my lord, on yes. I'm not disputing.
Not the fact.
It is a fact, but be that as it may, I'm not going into those disputes. We are really want to argue on the merit.
Virtually that is, I couldn't explain.
So my lord, on the last occasion, my lord was very kind enough to grant a direction within a specified timeline to complete the pleadings. So we have filed our.
So in 7 days time,
My lord, and next thing is
the interim order is extended till September 11.
Again, behind my back. Kindly see.
Fine, the matter was running in the list.
No.
If you don't keep a tag, that's really not our fault.
Okay.
My lord, kindly see, though the matter is listed today as 103, due to paucity of time, matter could not be taken up for hearing. Learned counsel for the petitioner submits that interim order. So it was mentioned out of turn. Be that as it may, I'm not going into that, my lord, a short time.
How soon you'll file? How soon?
Mentioning notice was there, not beyond that.
How soon you will file?
7 days. 7 days.
I will keep 1-2 days in a week for all our urgent here.
we understand the kind of pressure that your lordship
Absolutely.
Every day, but we are intimidated if we have item 1 or 2. We are scared to appear again. 1 week with filing will come.
Where is your affidavit now? Added respondent affidavit has come here.
Yes, my lord. May I just?
Added respondents file affidavit in opposition. After serving the complaint and counsel for the petition, and counsel for the petition place for extension of time to file reply. Let a reply be filed by by 26th August 2026 after serving copy to land counsel for the added respondent. Let the matter appear on 1st September within 10 matters.
I'm so grateful. I'm so grateful, man. But just one liner, my lord, the points of maintainability is kept open. Because, my lord, otherwise, maybe, my
the
lord.
point of maintainability is kept open. Point of maintainability raised by the respondent number, private respondent is kept open.
I'm so grateful, my lord. Yes, yes.
It's there. It's there. That order.
I don't know whether after the affidavit, I don't know how to.
No. He realized one judgment I passed. He has taken that.
He's now taking that advantage of that.
I'm so grateful, my lord.
Very deeply.
হ্যাঁ ওইটা 1 তারিখ রেখেছে মেইনটেনেবিলিটি আপনার মেইনটেনেবিলিটি
we file the reply
It is my humble file.
Reply filed. Reply filed. Recorded. Reply filed by the petitioner to the affidavit in opposition to the respondent number 3. We kept it. Yes. একটা কাজ করো वो लड़का आइडेंटिफाई होगा हमको बताना कोर्ट में. Yes, next.
I'm appearing on behalf of the petitioner.
Lordship, I'm for the Axis Bank.
My lord, I'm appearing for banking ombudsman, respondent number 2 in the matter.
I'd like to have your lordship can leave to file a supplementary affidavit. Since after passing of your lordship's order and after communication of that event and in presence of the learned advocates of the respondents, the order was passed. Till the deducted below the EMI, and lastly, in this one below the petitioner intimated me that 52,000 entirely has been deducted. Previously, 6,000 something every month they deducted by ignoring the order passed by your lordship. Now they have deducted this. For that, I have already filed a contempt application event. And that was intimated to them. In spite of that, this happened.
Lordship, in this regard, my humble submission is that all deduction were made inadvertently, Lordship. We are processing the refund. All deduction were made inadvertently through some technical issue, Lordship. And we are in the process of refund.
And if your lordship direct, we will refund this within 2 working days.
Very well, lordship kindly give that direction. Thereafter, matter may be heard. Entire deduction be refunded to you. Last order, lordship kindly please.
Who is appearing for the state?
Lordship, 25, I'm appearing for the state.
This is 25.
No, this is 24.
Because there is a direction, the officer in charge cybercrime police station, Alipur. The direct submit report.
He has also, he or she has not submitted.
Have you served us?
Yes, I have served. That's why your contempt application has been filed.
And this court has directed not to deduct any interest from the EMI. How your interest or
This is all inadvertently, lordship.
inadvertently, then your manager has to come. Then inadvertently the court will pass any order.
Lordship, we will refund this, lordship.
When you refund?
2 working days.
When you realize that amount?
Lordship, now I don't have received the document.
When the amount was deducted?
Right from the order.
No, after this order.
After this order, lordship kindly come to page 13 of the supplementary affidavit. Every time it has been done. 10th October 2025, 5,681 EMI deducted. Next page, lordship kindly come to 10th November 2025, 5,440. Then lordship kindly come to 10th December 2025, 5,452. Then lordship kindly come to 10th January 2026, 5,226. Then lordship kindly come to page 12, 10th February 2026, 5,229.
The petitioner has filed supplementary affidavit by disclosing the document that in spite of the order passed by this.
Lordship, if the state is unrepresented, your lordship, I can accept notice.
25th of September 2025, the bank has deducted the amount from the account of the petitioner. It is found from the record that on 10th October 2026, 11th November 2025, 11 November 2025, 10/12/2025 till
this month also.
March 2026, the bank has realized the amount from the account of the petitioner. Then counsel for the bank submit that inadvertently the bank has deducted amount from the account of the petitioner and on instruction submit that the bank will refund the said amount in the account of the petitioner within 2 working days from today. The supplementary affidavit filed by the petitioner be kept with the record. This court also find that by an order dated 25th of September 2025, this court directed the officer in charge cybercrime police station Alipur South 24 Pargana to submit report before this court with regard to the stage of the investigation, but nobody is represented the state before this court. Accordingly,
Lordship, Ms. Shayani Roy Chaudhary was appearing, your lordship.
but today nobody is here.
Lordship, I can.
In view of the above, the petitioner, the officer in charge cybercrime police station Alipur 24 Pargana is directed to submit the report to comply the order passed by this court dated 25th of September 2025 and to by filing the report before this court on the next date fixed. The petition is directed to communicate this order as well as the order dated 25th of September 2025 to the officer in charge cybercrime police station Alipur South 24 Pargana for compliance. List the matter on 3rd of September 2026 by filing report by the officer in the cybercrime police station Alipur.
Lordship.
Yes.
I'd like to bring to your lordship's kind notice on 14th of August 2026, 85,198. Entire amount has been deducted.
They're telling that they will refund that.
देखो,
Let's say what they are refunding. If not refunding, then they have to pay the
Lordship,
consequence.
I'll convey it to Ms. Roy Chaudhary, Your Lordship. She'll come back with instructions.
Next.
Milord, the
Refund, Your Lordship.
I am not participating. Your members are participating. I am the
Whoever has gone for the last
I am
rights.
participating in the proceeding.
May I clarify?
Your members are appearing. I am taking.
May I clarify? Whoever's gone for the
Your
last
members will
rights.
go out. I will go from this side. Your members will come and I will take the matter. There is no
we are
problem at all.
aware
And
that
your
330
just a minute. You are the you what post you are holding? Assistant Secretary. I am giving one work to you. One Mr. Shivam Bismaria is advocate. I want this advocate be present tomorrow at 11 before this court.
He is our member, definitely.
I don't know. He's appearing. He might be a member. Without the member, he can.
all the people, advocates who are appearing, they are not member of the bar.
So you give that he is not a member, then I will see how he can get the membership. This it's a copy करके रखो, नाम copy करके रखो. I want this person.
Milord, I have already filed contempt application. That should also appear on 3rd of September.
उसका number ले लो.
Item 20.
The content
25 is connected, right?
The content
No.
also be placed before this court along with the writ petition. Yes. Let inform him to appear before this court on tomorrow at 10:30 or 11, whatever it may. Let he appear. Let he come here.
Yes, Lordship, we are not aware of that court will rise at 2. We are
No, I am. The
that
court is
will-
here. If the members appear, the court will take the matter. If not appear, no.
It was the decision first that court will rise. They requested.
Okay, no
that
problem.
at 3:30 they will
No
court
problem.
will rise.
Yes, next.
Lordship, I am for the state, Your Lordship.
But I am covered by your lordship. My lord, in this case,
Yeah.
2,000 is the disputed amount. My lord, photo exchange of bank account 023. My lord, is my account number ending with 023. But I'm praying for defeasing of that account. My lord, on the last occasion, they have given us a copy of the report.
Malad, the last
Disputed amount
occasion, Malad has asked for the report. I have placed.
Covered by
Last occasion, Malad.
Similar lecture.
Yes, what is the report?
In the present report, Malad, we have
2,000 rupees.
Huh?
2,000.
Three transaction, my lord,
2,000 rupees. Malad, and presently, Malad, as per the report, we have received the objection, Malad, in present in annexure P3, Malad, from the station house officer. Page number, Malad.
P3.
P3, page number 19, Malad.
Yes.
Through which, Malad, we have received the notification regarding Malad freezing of the 3 specific accounts in which, Malad, the petitioner, in serial number 2, it's the petitioner's account. Through which, Malad, we have freeze the account.
Where?
Malad, page number 20.
Page 20.
Page 20, Malad. It is the email through which we have received from the station house officer, Malad, Mr. Kuldeep Tripathi. Through which we have received this instruction regarding defreeze of for freezing account of this 3 account in which serial number 2 is the petitioner's account.
Where there is a direction for freezer? Kindly read the page 20.
Malad, in page 20, it is
only ask for the details of the account.
Malad, details of the account.
Yes, where is
Then,
where is
Malad,
where is the direction for freezer?
In P4, Malad, we have received another email.
24.
We have P24, Malad.
Yes.
We have given, Malad, the notification regarding, we have given all the details of the account. Thereafter, Malad, in P6, page number 25.
No, page, kindly come to the page 24. We wish to intimate you that we have received the notice from Basti so and so. Accordingly, we have placed the debit freeze.
Debit freeze.
How?
Malad, thereafter 94 notice was served to us.
First, how you debit freeze? Who's given the instruction to you for debit freeze? He has only asked with regard to
Found,
the
matlab,
details.
it is the general rules that we just place the.
Show me the general rules.
It's rules. But this is
Make
this is
submission what is in
Matlab,
book and what is
Matlab,
in law.
that is what has been done by the
That's
bank.
why since beginning I'm telling, show me where is the law. The investigating authority has directed you to freeze the account or keep the amount lean.
Matlab, that is what has been done, Matlab, by the bank here. Thereafter, Matlab, we have received a 94 notice.
Where is the 94 notice?
Matlab, P6.
Account number provided some requested details. 94 is providing the details.
Details, Matlab, we have complied with such the details of it.
Correct.
In Matlab, in
Then-
such we have thereafter, Matlab, the since then, Matlab, it has been freezed out there.
Where is the freezer order?
Well, it has been marked as per the note, details has been served by the bank, Matlab, relating to that. We do not have any objection, Matlab, for defreezing.
What is the disputed amount?
2,000 rupees.
Where is that?
Page number 13.
Page number 13, Matlab.
13 of?
This report.
The report, Matlab, my report.
Where is that?
14.
14, Matlab, 14, serial number 10, the top one. 2,000 rupees.
Layer 3. 2,000.
2,000 rupees.
Yes. That's all.
That's all, Matlab.
Why you're not submitting? Why is this all matters given to the senior?
Sorry.
But as per the instructions I have received, Matlab, bank has no objection regarding, Matlab, the defreezing of the account. Matlab, Matlab, it's only 2,000 rupees, Matlab, let the account be defreezed, Matlab.
You persons are appearing, just the bar member has come and stated that there is a bar resolution.
No,
The petitioner has filed the present this application praying for a direction upon the respondent bank to defreeze the account of the petitioner being account number, being saving account number 28469170023 of Kotak Mahindra Bank, and to allow the petitioner to operate the bank account. Full stop. The petitioner submit that the petitioner is maintaining a saving bank account with the Kotak Mahindra Bank, but all of a sudden the bank, which date it was freezed, all of a sudden the bank has freezed
10/9/20. No. 10/9.
account. The petitioner has made several correspondence with the bank, but the bank has not. Bank has informed the petitioner that the bank has received the instruction from the cyber crime police station, and accordingly the bank has freezed the account of the petitioner. Accordingly, petitioner has 11 September 2025. Accordingly, petitioner has filed the present date application. This court has called for the report from the bank. The bank has submitted the report and submit that initially the bank has received an information from the cyber crime police station, district Basti, Uttar Pradesh, with regard to the details of the account of the petitioner. And accordingly, the petitioner has informed the details to the investigating agency by freezing the account of the petitioner. Subsequently, the investigating agency has sent a notice under section 94 of the BNSS asking the details of several bank accounts, including the details of the account of the petitioner. In compliance of the section 94 of the BNSS, the bank has submitted the details of the accounts, including the accounts of the petitioner. Then, the bank submitted the disputed amount with regard to the account of the petitioner is only rupees 2,000. The bank further submit that the bank has no objection if the court pass an order for defreezing the account of the petitioner. Concerning submission made by the counsel for the respective parties for use the materials on record. This court find that only the investigating agency has requested the bank for providing the details of the account of the petitioner. But while providing the details of the account of the petitioner, the bank has freezed the account of the petitioner. This court did not find, the bank has not produced any document that any investigating agency has requested the bank for freezer of the account of the petitioner, or the bank has received any order from any competent court for freezing of the account of the petitioner. This court also find that the disputed amount is only rupees 2,000. And the bank has already complied with the direction issued by the investigating agency by supplying the details of the bank account of the petitioner to the investigating agency. Considering the above, this court find that since the month of September 2025, the account of the petitioner has been kept freezed by the bank authority by the bank, and the petitioner is not in a position to operate a said bank account. Accordingly, the bank is directed to defreeze the account of the petitioner by keeping the disputed amount of rupees 2,000 in lien, and also to allow the petitioner to operate the bank account with the bank account. It is made clear that if in future if an investigating agency requested any further details to the bank with regard to the account of the petitioner, the bank shall cooperate with the investigating agency.
Much obliged. Direction
Next.
My lord, I am appearing for the petition. My lord, matter is relating to the payment of the petitioner parents matured deposit amount with interest. My lord, the petitioner's parents, Prafulla Kumar Da and Josna Da, wife, since deceased, both senior citizen deposited 50,000 initially in the State Bank of Hyderabad at Lasdown branch, which is now State Bank of India at Nisampur, state certificate is, my lord, and on 8/8/2007. The maturity due 8/8/2008. The said amount with accrued interest, my lord, has 60,000 each. My 10 certificate. Kindly have a look, my lord, page 18-2.
Yes. Now what has happened?
27.
What has happened? So the grandparents were having the 10 fixed deposit, 60,000 rupees with maturity amount. So what has happened thereafter?
We are represented again and again,
Ah.
and the bank.
So bank has not admitted,
my lord.
Bank has not paid the amount.
No.
So what is your prayer?
Prayer for maturity amount with compensation and accredited A and D, my lord. They are A and D. Kindly have a look, my lord.
Okay. Yes. Why you are not giving?
Kindly sees what they are showing, my lord. They have submitted on affidavit. They are saying that they have submitted on affidavit, my lord.
Ah.
My lord, kindly sees their affidavit.
Where is the affidavit?
And the bank already admitted, my lord. Kindly have a look, page 50.
50.
Page 50.
Seven fixed deposits, so and so are live and lying with the Beltalla branch. Another are not traceable at our end. On the fixed deposit, they have written home branch changed to our branch, but in the system they have not been transferred. Yes.
My lord, kindly sees page 30, my lord.
50. Yes, I am
30, my lord.
30.
They are saying that this affidavit
30.
30, my lord. 30.
Yes.
Their father, Prafulla Kumar Dan, has submitted this affidavit before the bank for nomination. The question is of nomination, my lord.
No. Kindly come to page 50.
50, my lord.
Not nomination.
But if he is not a nominee, my lord, his deposits are of his
Come
father.
to the page
My lord,
50.
my lord,
First you come to the page 50.
my lord.
This is which year? Which date?
24, my lord.
Yes,
My lord, it was
page 50. They are 2018.
Yes, my lord. Parthodan Padmapukur notice of for payment of fixed deposit. With
Correct.
reference to your letter dated such and such, you have asked for payment of below mentioned fixed deposit account number such and such, in which the 7 fixed deposits account number are live and lying in Beltola branch and another are not traceable at our branch. One on the fixed deposit they have written home branch, changed to our branch, but in the system have not transferred. Under this circumstance, we are unable to payment the above fixed deposit. Kindly verify at our Beltola branch.
So who has written this?
This written, my lord, it appears a branch manager.
Despriya branch?
Yes.
Despriya Park branch.
Yes, my lord.
Yes.
But my lord, what I have been instructed, my lord, I am a creature of instruction, my lord. What I have been instructed. My lord, instruction is this, my lord, this is, there is no nomination in the records of the bank in accordance with Form DA1. My lord, this is the Form DA1 under 45, section 45.
May I submit?
Under section 45 ZA. Unless there is a nomination, my lord. Section 45 ZA of this act of Banking Regulation Act of 1959.
ZA.
ZA. That is the act, and I'm showing, my lord, the Form DA1.
45 ZA.
45 ZA.
Nomination for payment of deposit, yeah.
Yes, my lord. So that should be a nomination form as per that form, my lord, DA1.
First you have to satisfy
my lord.
the first letter which has been given by the bank, the branch bank. They are telling that out of 11 fixed deposits,
7 are lying.
7
lying.
And other 4 are not having. Because in one of the fixed deposits it is written that it has been transferred to the home branch, but it is not reflected in the system. So now first you satisfy this out, or you tell this court whether all the 11 fixed deposit are with you or not.
No, my lord.
Huh?
May I come back tomorrow, my lord? Or day after tomorrow?
So if with you,
yes,
then you have to come with the total report with the whether all the nominations are there or
my
not.
Lord.
Nomination is not there, then
Not there.
The law is different.
Yes, my lord.
If nomination is there or E&S is there, whatever it may be, or it is a joint, then the law is different.
My lord.
Correct.
My lord, there are some checkered facts also, my lord. These facts have been suppressed, my lord. My lord, for your assistance, I am planning this.
In the page 30.
These facts have been suppressed from my lord.
Page 30 already nomination paper already given.
Let
and not
30 is an affidavit, my lord.
Is the regulation, my lord. Kindly.
You file the consumer's case.
Yes, my lord.
You file the dismissed. So it is res judicata.
Withdraw.
Well, kindly see
with the liberty.
No, my lord.
Withdrawal with liberty.
Liberty is not.
This is the order, my lord, of the
Not
consumer
issue,
forum.
my lord.
Last order of the consumer forum.
Yes, there is no liberty. And you ask for the withdrawal.
My lord.
Then how that it is maintainable?
My lord, there was no only the paucity of judges, my lord. And not that
Judges was an order, not the peon.
No.
Then you have asked before the tribunal.
Since many days there.
Correct. 8 years. Whether you have taken leave for file afresh. You know the CPC? No. So where is the liberty?
Not taken.
Then how you file the new case?
But regarding the nomination, my lord, already.
I am asking with regard to the maintainability. How the writ petition is maintainable? Once you file the complaint case before the Consumers Tribunal, Consumers Commission, and now you have come before the withdrawal that is also in the year 2018, March 2026. Then
as there was room, just since the long. The
So
case
you
was
could have been
pending
taken the
in
liberty.
Consumer Court.
So you take the liberty from the court. How the writ petition is maintainable?
And
To pass the order of liberty. Court is competent and no bench is there. That's why, madam, after long 9 years pending in that case.
Who has signed? Who has signed the order? President and members were present. President is also present. So how you are telling that the forum is not functioning? Due to you persons, the ill advised, the clients are suffering.
Yes, madam, many times. We also went to the state commission, the order of state commission also there, but till that fine has been charged.
So it is not curable. How you can cure these defects? Go read and come.
Liberty.
I'm coming to
I have become a teacher.
My lord, the petitioner is 79 is old.
But what can be
He's
done?
suffering from old age. He is not getting any relief from any.
But you have done the blunder. You have done blunder. Yes. But
My lord, there's a series of facts. My lord, they have also approached this honorable court also. Since the court was not functioning, matter was transferred. They paid for a transfer of the matter to a different consumer court. So that was rejected. With challenging that rejection, a civil revisional application was filed before this honorable court. This honorable court, and there was a cost imposed. The honorable court waived that cost. My lord, kindly cease, and directed the consumer court to hear this matter expeditiously. And before the consumer court, they asked for the nomination form. The consumer court particularly asked for this nomination form. They could not submit the nomination form. They withdrew the matter.
My lord, may I submit, my lord? Regarding the nomination form, my lord, the bank is only custodian. Kindly have a look, my lord. 45 Y.
All these facts have been
do
suppressed.
one thing.
All these facts.
If you want to settle the issue, go to the bank. Your grandfather is old age. Go to the bank, file a nomination form, and get rid of.
My lord, the petitioner only nominee is there. Nominee is there, and all depositors already gone.
Original depositor is not alive. So in the original deposit form, there is no nomination. Nomination is there.
And nomination is there, my lord.
Where is the nomination?
Page 30, my lord. And the bank is the only custodian, my lord, according to 45 Y.
This is not the nomination, sir. Page 30 cannot be a nomination.
Page 30.
How it can be a nomination?
Page 30.
Yes, it's a bond.
My lord,
By the bond, nomination can be made.
Is a nomination already notary.
Huh?
Notary.
It can't be. For the nomination in the bank, there is a separate procedure. Have you filed the nomination form before the bank? So now the original person has died. How you can nominate?
But not in the custody of the.
You go and file a succession certificate, nothing else. Only thing is a succession certificate. Or no further relief can be granted. You go to the succession certificate, pay the court fee and all these things. If it's 60,000, then you have to pay this 10,000 to the court fee. Then you will get the decree.
Then kindly with this my lord, liberty be given. Or with this matter nothing.
The petitioner has filed the present date application, praying for a direction upon the bank for payment of the amount of rupees 50,000 along with interest and compensation. It is the case of the petitioner that the father of the petitioner. Huh?
Father and mother, parents.
Father and mother of the petitioner have opened the have deposited the amounts in 11 fixed deposits.
My lord, 10 certificates.
7 fixed deposits.
10 certificates.
Rupees, totally amount of rupees
With the petitioner.
50,000, but the bank has not, but the mother and father of the petitioner has died, and the petitioner has applied for release of the said amount, but the bank has not released the same.
Original certificate
And
not with the
consequently, the
client.
bank has raised the point of maintainability of the said writ application and submit that the petitioner has initially filed a case before the district consumers forum. And for expeditious disposal of the said case, the petitioner have filed the writ petition before this court. Subsequently, the petitioners have filed an application for transfer of the case from one consumer's forum to another consumer's forum. The same was dismissed by this court. Subsequently, the petitioner has filed a civil divisional application. The same was also dismissed. Finally, the petitioner has withdrawn the case filed before the consumer's forum. Now the petitioner has filed the present writ application. This could find that the writ application is not maintainable as the petitioner has withdrawn the case filed before the district consumer judicial forum on 16th of March 2026 without any leave to file afresh or to take appropriate steps. Accordingly, writ petition is dismissed. However, the dismissal of the writ petition will not prevent the petitioner for taking appropriate steps before the appropriate forum for realizing the said amount from the bank in
My lord,
accordance with law.
My lord, original certificate is lying with my client.
Okay.
Liberty is given, my lord.
What given? Next.
Not apply.
On it. Yes. What is the grievance with my officers? Why you have misbehaved with my officers after rising of the court?
Lordship, I have not misbehaved.
If you have any problem, you tell to the court. Court is taking all matters. Why you have mingled with the officers of the court?
Lordship, I am not.
Why you are misbehaving that? You want your name should be sent to the bar council, or I should Somotot can initiate the proceeding. Please don't do in any court with the if you have any grievance against the officers of the court, inform to the court. Not to mingle with the officials. If the officers are not doing any work, if you have any problem with regard to your file or matters, please inform this court with regard to this court. This court is taking all matters.
I apologize.
Please mind it. Henceforth, not to do all these things. Thank you. Yes, call the matter.
27. There is a connected application. You appear for a petition. Please come to
Mr. Bhattacharya, you are setting my cause list along with the time. Every time in the last moment you are coming in, your matter is called.
Base of everything is there.
Okay, thank you.
So please come to page 15 of my application.
15, 15. 50?
Yes, 15.
Yes. Application?
In the application.
Writ petition. Can
Can 1 of 2026.
You have an extra copy?
That's the copy of.
Can one?
Here, essentially, I have prayed, for an appropriate direction at page 12. But this is concerning a dispute pertaining to a society registered under the Societies Registration Act. Where we have alleged some issues with the registrar of society. I was only humbly beseeching the Lordship comments that there will be no election. These are the nature of allegations. One way of looking at the problem is to end it there. That was one time it was understood. Today we are essentially seeking appointment of some special officer appointed by this court who will conduct the election, hold the election. And till that time, he will be the custodian of
You are not having the bylaws.
right?
So what is the how the election is to be conducted?
That
Firstly, only one thing there is, I am for the society. Society means for the secretary, I am appearing in person.
You are the secretary.
And for the treasurer, I am appearing for him. Fact is this, so I cannot.
You are appearing in person and you are appearing for the other.
Other also, I have to.
Give to some other junior. I will allow, but not to you if you are appearing.
Only
in
one
person.
thing, my lord. Fact is this. I'm sorry, my lord. I will do it. One thing, my lord. The petitioner has already filed a suit before the Barasat court, and the Barasat court, learned Barasat court, is taking cognizance of this same, and that is going on there. Already written statement have been filed. Everything has been continuing. Now they are praying for an order of this court that will cause influxus of the Barasat court application. I have already annexed the Barasat court application before this honorable court by an opposition. So now I leave it to your lordships, what your lordships to do. So fact is this.
The prayer in the suit.
Barasat court, man, I'm placing my. That is in my opposition. Same petitioner has filed a suit.
What is the prayer?
I am showing. That is at page 16 of my opposition.
Decree declaring the tenure of the governing body started functioning 7 months come to an afflux of time.
May I read, my lord?
Yes.
Page opposition.
Page 25.
Page 16 also the opposition is there in my opposition.
Yes, your opposition, page 25, inner page 16 of your.
Inner page 16.
Yes.
A degree of declaration that the tenure of the government body restarted functioning on and from 7/7/23 has come to an end by a flux of time. Declaring the meeting convened on so and so by defendant number 2 as patently illegal, ultra vires and a blatant violation of statutory provisions, association, bylaws, and fundamental principles of administrative law. An order of permanent injunction may be passed against the defendant number 2 and 3.
So when the election was held?
Election was held 7 years back.
What is the tenure of the election?
1 year. Thereafter, Corona was there. Everything was there. This person was the president of that election. Finally, last year, the person has been removed as a president.
challenging this suit has been filed.
Challenging that suit has been filed, and the suit election has been played. Election has been played for in the suit. The suit is running. On the way they have filed this. My lord.
If you both all ready, let the election be conducted. Once the election conducted, I pass another. He will withdraw the suit and the petition.
My lord. I am sorry, but
if both the parties ready, let a special officer be appointed and election will be conducted. And I will take undertaking that once the election is, he will not.
I hope that a party hear the. I am sorry, madam. I am taking some time. The register of society has been made a party. Let the register of society decide it. That is their prayer also.
Okay, that can be done.
So there is a previous order made by the court, not the register has it.
No, what I am telling, once the special officer, one special officer appointed by this court, he will conduct the election and he will submit the report.
Register of society decide that one.
Again,
because they are not paid for any special officer appointment.
Correct.
That is not there in the petition.
Correct. But this court is of the view that once for all the matter can be resolved by all.
Let the register of society decide that. If the register of society decide, because special officer, we are, in our bylaws, we appoint the members appoint the election officer. So in that case, the register of society decided.
Where is the prayer? Subordinate carry out the inspection. There is no prayer.
The application.
There is no prayer there regarding that. No prayer.
Can one not prayer at page 12?
In the application, I have not used any opposition also. So far, I am not going to that confusion. No prayer is also there in any manner. Read code has long arms. Read code has long arms.
Okay, you do one thing. You got the can one.
Can one?
Have you got? or you give the copy, come on the next day, consider this.
No, 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 no.
Give the copy of Can 1.
Copy of the Can 1 will be given.
You take instruction and come back. If you take instruction, if the registrar will say that he will conduct, then I will pass appropriate order.
Yes, registrar will decide that.
You take instruction.
My lord, I am taking it.
Who is for the state?
No, state is not appearing here.
That's why problem.
That
If
is
you pass an order,
the fact is this registrar may be disposed of by
none appears on behalf of the state.
We also want election.
Accordingly, petition is directed to inform the next date of hearing to the state to the government pleader and to file affidavit of service by the next date fix. It is made clear that on the next date fix, if none appears on behalf of the state, the appropriate order will pass. List the matter.
This order may be passed by your lordships, always subject to your lordships approval.
Let the state come.
Only one thing, let them serve a copy of the application to the state also. Because again they will come and say that no application is there.
Okay. Come on.
Returnable date?
3rd September.
3rd September.
Cross.
Look, before your lordship takes up the original site, there is a resolution. From 2 p.m. There's a corrigendum to the before your lordship takes up the original site. This matter is appearing in the list, but the interim order is expiring today.
Which one?
Could not be called on item number.
Which service? Serial number?
67. 79.
70?
79, please.
Today?
Today. It's there in the list today, madam. Kindly see paragraph 9. Paragraph 9.
18th August. 79?
Yes, please, madam.
Yes. Though the matter is listed as item number 79 in the day's list, but due to paucity of time, the matter could not be taken up for hearing. And counsel for the petition, I mentioned the matter and submit that the interim order is still today and paid for extension of interim order. In view of the submission made by the counsel for the petitioner, the interim order is extended till 22nd September 2026 or until further order, whichever is earlier. Let the matter remain in the list.
Well, have been pleased to direct.
Can I? May I have your lordship's kind leave to mention the original side matter?
Please wait. Let the officers change.
Oh, very well.
I'm led by Mr. Rishabh Banerjee.
Yes, Mr.
No, Malaj, I'm so sorry. Yes, Malaj, I'm so sorry to mention it, Malaj, on the virtual platform. Malaj, this is item 145 on your lordship's list. The urgency is, Malaj, my account has been declared as a fraud account when I am not a director, not a promoter, not a shareholder of a company, without any Malaj, personal hearing. I'm covered by your lordship's judgment in Hemant Kanoria. Malaj, I just need 5 minutes of your lordship's time any day. 5 minutes of your lordship's time any day. Well, there is no forensic audit report also. That's the most shocking part. There is no forensic audit report also.
That is the problem. But
any day, Malaj, 5 minutes any day, Malaj, it's in July. 5 minutes any day.
145 को कोई दिन ऊपर कर देना. Yes.
Malaj, next Wednesday also, if your lordship wants to do it on 27th also, it's fine. If your lordships can do it on 27th at Malaj, on the top, Malaj, 3 o'clock or 3:15 for 5 minutes.
Court applying urgent motion. Yes. 27 it will come.
I'm grateful. I'm so grateful. I'm so grateful. I'm so grateful. So deeply.
Mention item number 137 from your lordship's list, my lord. This matter was fixed on 14th August at 3 p.m., my lord. It's a motion matter. The respondents didn't appear because of a resolution. But I'm only praying if your lordships may kindly upgrade, my lord.
136.
137, my lord.
Yes. Who is for the other side?
Lord, it's not the other side that you have mentioned.
You are for the petitioner.
Was fixed at 3 p.m. My lord. The lordships have also taken cognizance of the affidavits of service. Because of the resolution, my lord, we've annexed that order also of 14th August.
Then we date has been September. September?
First week of September, my lord, because I'll be praying for interim reliefs.
That is the first date available, or otherwise it will be remain in the.
My lord, in that case, if your lordship may kindly upgrade the matter, my lord.
It can't
It
go
could be in
which
the
will-
first 5 matters, my lord. I'm grateful.
Yes,
May I have the last name?
yes.
The item number 138 of your lordship's daily list today. But what has happened is my demat account has been freezed. But since 2022, there were continuous correspondence between the respondent and the petitioner. But it's appearing as item number 138. The petitioner is an overseas citizen of India. He is a British passport holder. If lordship can give some presentation.
British, what is the necessary? What is the urgency in India?
Demat account has been freezed. All his investments, he cannot operate his demat
So
account.
you will get the amount from the Indian bank in the Indian currency, but
Lordship would kindly consider
you will get the dollar in the foreign.
Neither a promoter nor a director, my lord, his account has been freezed on instructions of the Calcutta Stock Exchange. Lordship would kindly consider.
How much matter I can upgrade? Tell me.
But it would not take more than 5 minutes, my lord. I'll affect.
Every matter is the not more than 5 minutes, but what can be done?
It's a genuine request.
Okay, let me see. Let me see.
But may I hand over the slip?
Yes, give it to them.
I'm
Yes, next.
No, there's a 345 fixed matter, my lord. Mr. Burnley is there on the other side that police authorities, my lord, wanting to purchase my property.
Police authority will purchase your property.
Yes, that writ petition.
Good.
Finally, we've got hold of Mr. Burnley, my lord. So, my lord, if your lordship kindly 345 call from. We are here.
Ready? Yes, call the 3 p. What you mention? 345. Let if both the party will there, then I will take them. Yes, call the matter.
My lord, I'm challenging the maintainability of this application also. So, my lord, may I place why it is not maintainable?
My application, my lord, I have to
I know.
actually start.
But I have challenging the maintainability.
I'm
Let me
also
show
challenging
you.
your maintainability.
My
Of
lord,
the
first let me
application
show
on
that the application
which, my lord,
itself is not maintainable. If your lordship finds the application is not maintainable, there's no question of any further
I just give my
application.
learned friend can do that. My lord, there's a decree which was, my lord, there. My lord, my learned friends and we are also saying the same thing. My lord, my learned friends, my lord, made an application to, my lord, record a satisfaction of the decree. We are saying that that was illegal. They couldn't have been done it. That was done fraudulently. Now, my lord, there's a dispute, my lord, with regard to, my lord, who is really representing, my lord, the plaintiff itself. So quite naturally, my lord, I am saying I am, my lord, the correct, my lord, representative of the plaintiff. And my learned friend says, no, they are the correct
What
representative.
is order?
I am saying it, my lord, this
What is recalling?
It's a recalling, yes.
By a third party. By a third party. I am challenging the maintainability of this application on 2 grounds. Number one, my lord, a recalling application by a third party to a disposed of proceeding is not maintainable at all. It cannot be agreed. So that's number one point. And number two, the applicant here, my lord, applicant cannot maintain the application on behalf of the in the manner it has been filed. So let me place that. my lord.
We'll address both parts. We'll address both issues. We'll address both issues.
Yes, my lord.
That's the ground you have taken in the affidavit. We'll address both issues.
Let it be addressed, but let me place, my lord, why it is.
No, but it's my application.
I am saying the application is not maintainable. So
That's in the affidavit.
So why it is not maintainable, that point has to be addressed first. My lord will kindly take the application itself. My lord, your lordship will find that the application has been filed by 3 persons. Your lordship, my lord, sees the my lord, page 3 of the cost title. After the cost title, your lordship will find B. There's Krishna Damani, there is Sushil Kumar Daga, and Sudeep Roy. 1, 2, 3. And my lord, if your lordship takes the paragraph, para 1, starts, we are the trustees, member of the managing committee, and treasurer of the decree holder. Bellevue Clinic, above named, above the clients. And then the para 2 is very important. The applicants are filing the instant application in support of the master summons for recalling the order dated 8 September. Now, my lord, kindly takes para 5. The applicants above named are all trustees and members of the managing committee of the society. Apart from being trustee and member of the managing committee of the society, Sushil Kumar Daga is also the honorary secretary. The secretary and member of the administrative committee set up by the managing committee of the society to supervise the implementation of certain decisions inter alia in respect of the projects undertaken by the society. The provisions of the said act, read with the bylaws, confer Sri Sushil Kumar Daga, being the honorary secretary of the society, to sue for and on behalf of the society. So, my lord, the application is being filed by 3 persons. As on the basis that one, the Sushil Kumar Daga is the honorary secretary who's entitled to sue for and on behalf of the society, and 2 others who are claiming themselves to be trustees and member of the managing committee. Now, my lord, whether they can maintain a proceeding on behalf of Bellevue at all or not, that it's a society. Now, my lord, kindly takes my opposition.
Opposition filed?
My lord, opposition has been filed. My lord, my first contention is, my lord, this Mr. Daga, he is not the honorary secretary. Only the secretary can maintain a proceeding on behalf of the society. So none of the 3 could have maintained this application at all on behalf of the society. My lord, if your lordship takes, my lord, my application, my opposition. Your lordship will, my lord, come straight, my lord, to page 642, which is the last volume. The last volume.
Yes.
My lord, your lordship will see, my lord, this is a page 642 is a resolution of the managing committee held on 29th February 2024, by which, my lord, your appointment of honorary secretary of the society resolved that in supersession of earlier resolutions passed in this regard, Sri Ashim Chattopadhyay be and is hereby appointed as the honorary secretary of Bellevue Clinic with immediate effect, that is from 29th February 2024. Further resolved that in supersession of all resolutions passed in this regard, Sri Ashim Chattopadhyay be and is hereby authorized to do all such acts, deeds, and things necessary and incidental in this regard as per the rules and regulations of the society and as authorized by the managing committee of the society from time to time. So, my lord, as per this resolution, from 29th February 2024, it is Ashim Chattopadhyay who is the honorary secretary.
Yes.
And not Mr. Daga. Mr. Daga was there previously, not from 29th February 2024.
Yes.
This was also, my lord, informed to the registrar of firms and societies.
When this application is filed?
My lord, this application is filed in 2026. Your lordship will kindly take, my lord, the affidavit.
Yes, 11th February.
My lord, it's filed on 22nd January 2026. So much after. So on 22nd January 2026, neither Mr. Daga was not the honorary secretary and the other 2 anyway are not entitled to maintain the proceeding on behalf of the society. Now, my lord, kindly takes page 64 of my affidavit, volume 1. Volume 1. My lord, immediately after 29th February, after the resolution, my lord, this was the change of the honorary secretary was also informed.
Yes.
My lord, to the registrar of firms and societies.
Yes.
My lord, that your lordship will find, my lord, of 13th March 2024.
Yes.
Your lordship will find, my lord, the present list of trustees at page 64.
Yes.
At page 65, your lordship will find, my lord, the list of managing trustees, managing committee members.
Yes.
And, my lord, your lordship will find, my lord, at page, my lord, page 65, right after, my lord, the first list of names which are there, 1 to 8, after that, the members of the managing committee of the society at its meeting held on 29 February 2024 have also appointed Sri Ashim Chattopadhyay as the honorary secretary of the society in place of Sri S.K. Daga erstwhile. So this was also informed. Your lordship has found the place, Manor?
Yes.
So this was also informed to the registrar of firms and societies. Page 63. 63?
65.
No, 64. At 65.
Yes.
And this has obviously also been signed by Ashim Chattopadhyay. Now, my lord, this Mr. Daga Damani and Mr. They have previously also tried to come to court and say that the appointment of Ashim Chattopadhyay is incorrect and it should not have been done. The resolution is bad. They've come to court before in this regard in a different suit. Now, my lord, they tried to move an interlocutory application also. My lord, that was the injunction was refused, and also, my lord, Ashim Chattopadhyay's status as the honorary secretary was for the time being upheld. Now, my lord, your lordship will see, my lord, the order which was passed in this regard of Justice Shampa Sarkar. Your lordship has seen this order in a different point of view. My lord, now if your lordship sees with regard to who the honorary secretary is and regarding these resolutions, my lord kindly takes page 414 of the application. Well, they have annexed the order themselves. It's the order of 22nd May 2024. Volume 3 of the application.
Yes.
Page 414. Your lordship will see the cost title which is there, my lord. Bellevue Clinic versus Anamika Lodha. Bellevue Clinic versus Anamika Lodha. Order of 22nd May 2024.
Yes.
My lord, if your lordship takes, my lord, the first page 415.
Yes.
The second paragraph. GA1 is an application for injunction filed in connection with CS 156. The petitioners are plaintiffs. The petitioner is a charitable society registered under West Bengal Societies Act, Registration Act. The petitioner number 2 claims to be the member and to be a trustee and member of the managing committee of the society. The defendants also claim to be trustees and members of the managing committee on the basis of a resolution dated 26 February 2024. The defend number 3 claims to be the trustee and chairman of the managing committee. The petitioners have filed an application for temporary injunction restraining the defendant respondents from acting in terms and furtherance of the agenda notices dated 22nd February 2024, 27th February 2024 and 13th May 2024. Lordship will kindly mark the 27th February 2024. This is the notice. My lord, if your lordship takes the next paragraph, the notice of 22nd February 2024 was issued by Anamika Lodha as one of the trustees to the society. By the said notice, an emergency meeting of the trustees was called on 26th February 2024. Well, then there's the agenda I'm not reading out. Your lordship goes right after the agenda. By a notice of 27th February 2024, an emergency meeting of the managing committee was scheduled to be held on 29th February 2024. It is this meeting of 29th February 2024 by which Ashim Chattopadhyay has been appointed, my lord. So this was a meeting which was under challenge, my lord, 29th February 2024. My lord, if your lordship now comes, my lord, to page
425.
422. Your lordship
425 is the last one.
425 is the last. But if your lordship takes, my lord, 422, my lord, 5 lines from the bottom, 6 lines from the bottom, in fact.
Yes.
The agenda notices were issued on February 22nd and February 27th, 2024. The petitioners received the notices and raised objection but did not take any steps to prevent the meeting from being held. Accordingly, resolutions were passed and adopted. It is this resolution by which Ashim Chattopadhyay has been appointed as the honorary secretary. They need no recomposition. The need for recomposition of the trustees and managing committee has been prima facie answered by Mr. Mitro. Such need arose as one of the trustees and members of the Damani. My lord, if your lordships, well, let me read it out, my lord, because it's important. Mr. Damani was charge sheeted. He was unable to function on account of his arrest. The prayer for bail has been rejected. Mr. Daga, the second petitioner number 2, is also facing criminal investigation. The charge sheet upon completion of the investigation against Mr. Damani was placed before the court. The investigation agency indicated the complicity of Mr. Daga was prima facie available and further investigation was necessary. It is further contended that the application for anticipatory bail filed by Mr. Daga has been withdrawn. Learned senior counsel submits that a person who is an FIR named accused cannot continue to manage the affairs of the society, and other persons have been arrested. Investigation is going on in respect of Mr. Daga on allegations of defalcation of funds of the South Point School. Now, thus, Ashim Chattopadhyay was made honorary secretary. I further find that regulations prima facie do not prohibit a trustee from calling a meeting. Mr. Ashim Chattopadhyay was appointed as the honorary secretary in one of the meetings held on the basis of Shri Anamika Lodha's notice and resolution has been adopted. It is the petitioner's own case that they have been constituted. Now, my lord, last line here, my lord, prima facie, it appears from record that the meeting of 26 February and 29 February were held physically. And now, my lord, coming straight to page 425, my lord, the second para, in my view, the authority of Anamika Lodha, appointment of Ashim Chattopadhyay, the validity of the notices by Ashim Chattopadhyay calling for meetings are all to be decided in the final hearing of the injunction application, as also in GA2, which will be heard on affidavits. Well, this is still being decided. But as of now, Ashim Chattopadhyay's status as the honorary secretary continues, and there is no one else who is the honorary secretary. Mr. Daga cannot claim to be the honorary secretary, it was not accepted. So now, my lord, coming back to this application again, my lord, if your lordship takes that para 5, the very basis of this application, my lord, is that Sushil Kumar Daga is the honorary secretary, my lord, para 5 of the application. Your lordship takes the trustees above named are trustees and members of the managing committee. That does not entitle them to file a proceeding. It is only if they are honorary secretary. That's why, apart from being the trustee and the member of the managing committee of the society, Sushil Kumar Daga is the honorary secretary. And then the last 4 lines, the provisions of the said act, read with the bylaws and of the society, confer authority on Sri Sushil Kumar Daga, being the honorary secretary of the society, to sue for and on behalf of the society.
Yes.
So, my lord, if Mr. Daga is not the recognized honorary secretary of the society, my lord, he cannot maintain the proceeding. There cannot be 2 honorary secretaries.
Yes.
As of now, it is Ashim Chattopadhyay. So, on the very face of it, this application is not maintainable by Ashim Chattopadhyay, by this Mr. Sushil Kumar Daga. Other 2 cannot maintain the proceeding at all. That's my first point, that the application is not maintainable. Now, my lord, secondly, now, my lord, your lordship will see why this application has been filed. My lord, the prayer, if your lordship comes, takes the prayers in the master summons. My lord, first prayer is condemnation, second prayer, prayer B. Oh, my lord, your lordship will take the master.
Yes.
My lord, your lordship will take, my lord, the master summons. Prayer A is condemnation. Prayer B, order granting leave to intervene. So they are seeking intervention. Second is recalling. Third, C, prayer C. An order recalling and setting aside the order of 8th September 2025 passed in EC so.
Yes.
And then, my lord, the interlocutory release which are there.
Yes. Yes.
My lord, before I come in, if your lordship just takes one more, but with regard to the maintainability regarding Mr. Daga's locus, my lord, your lordship will kindly take the opposition, page 622. 622.
Yes.
Well, in a different proceeding, will be your lordship's order, if your lordship takes 21st June 2024. Well, if I just come straight, well, I don't want to, well, para 29, if your lordship takes, I don't want to ponder, my lord. The lordship comes straight to para 29 at page 6. Well, para 20, well, if your lordship takes page 638.
638.
638, para 28. Well, your lordship takes in CS 153 of 2024 in an application GA1 was filed by Eastern India Educational Institution. Well, this is another society. There were similar societies, similar resolutions were passed, my lord. And another for grant of interim order in respect of a notice dated 27th February 2024, where an emergency meeting of managing committee was called for on 29th February 2024. The coordinate bench of this court refused to grant ad interim order and held that, my lord. Your lordship, well, this order is of Justice Sarkar, which your Lordship has quoted. If I just like Lordship take the last 5 lines, the division bench coming from a specific finding to that the APL did not have jurisdiction or right to interfere with the internal affairs and management of the committees, management of the companies under the MP Birla group of companies, held that the resolution dated 4th March 2021 has become inoperative. Well, this is the Justice Shampa Sarkar's order, your Lordship has quoted. After that, para 29. At the time of the order passed by this court, on the previous occasion where the plaintiffs have prayed for an interim order with respect to the AGM dated 22nd September 2023, at the relevant point of time, there was no order of the division bench dated 14th December 2023. This is the order of Justice Sivananam and Justice Bhattacharya. After the order of the Honorable Division Bench, the circumstances has changed, as the Honorable Division Bench has held that the testamentary court cannot pass orders directly in respect of management and affairs of the corporate.
No, this 22nd September 2023 order
That
of the
was the
Justice
AGM.
Mukherjee.
That was the AGM.
That is the order of the Justice Mukherjee.
22nd September 2023.
That is the first order of
Justice Arinda Mukherjee. There's one order, yes, order. Well, here but if your Lordship sees, the 22nd September is being discussed with regard to an AGM of 22nd September.
Correct, that's why.
Yes, my lord. And then, my lord, that order of justice, the division bench order was not there. That's what your Lordship notices.
Yes.
At the relevant point of time, there was no order of the division bench dated 14th December 2020.
Earlier Justice Mukherjee passed an order. In between, just the division bench passed an order. Then the writ has come to me with regard to, with the application.
Absolutely, my lord. After the order of the division bench, the circumstances has changed, and the Honorable Division Bench has held that the testamentary court cannot pass orders directly in respect of management and affairs of the corporate contractual rights of other entities, including companies, trusts, etc. The Honorable Division Bench also held that the very composition of the APL proves conflict of interest, since 2 members represent the warring factions and have left no stone unturned to show their colors in that regard. The only way in which the APL can function effectively is for the 3rd member, who is necessarily a retired nominated judge, to act as arbiter in case of conflict of decision between the other 2 members of the APL. It is also held that the APL must also keep in mind that it is not an adjudicatory authority but merely representative of the estate of the deceased. Now, my lord, para 30. The question raised by the plaintiffs that the plaintiffs have not proposed the name of Kailash Chand Mittal to be a director, and no documents have been produced by the defendants to establish who has proposed the name of Kailash Chand Mittal, is also not clear that who will represent the plaintiff number 4 in the said meeting. The plaintiffs have also raised the question, is there any meeting held in the month of May 2024, and that the Honorable 2 retired judges in terms of Section 160 of the Companies Act. It is also submitted that the 2 retired judges have not received any notice from Shri Anamika Lodha. The court also finds that there is a dispute with regard to the representation of the plaintiff number 4. In one hand, the learned counsel for the plaintiffs claim that they are appearing for plaintiff number 4 also. And on the other hand, Mr. Jishnu Chaudhary has informed the court that the plaintiff number 4 has taken a resolution to appoint him as counsel for the plaintiff number 4. And he is having the Wakalatnama affidavit of competency and the resolution of the plaintiff number 4. Thus, there is also a dispute with regard to the representation of the plaintiff number 4 in the present suit. This court also finds that the plaintiff can raise all points urged before this court before a scrutinizer and in the meeting which is scheduled to be held on 24th June 2024 as per notice of 62nd AGM of 28th May 2024. This court also did not find any material on record restricting HBL from exercising voting rights on behalf of the society in other entities of MP Birla Group. Considering the above facts and circumstances, this court finds that the plaintiff has not made out a prima facie case and balance of convenience or inconvenience in their favor for grant of interim order. Accordingly, is refused. So, my lord, similar issue there also, my lord. They were claiming that they are the representatives of plaintiff number 4, that is the society, on the basis of that same resolution of 29 February 2024, where your lordship, my lord, did not grant them interim relief. So, my lord, by that resolution of 29 February 2024, Ashim Chattopadhyay's position as honorary secretary has not been touched by any court of law, and it is still the same. So, my lord, Ashim Chattopadhyay remains honorary secretary and no one else. So, Mr. Daga cannot claim also to be the honorary secretary, as has been claimed, on the basis of which they are claiming the right to sue. So, that's my lord, that was the first point. My lord, the second point, which my lord, I showed the prayers So first prayer was condonation, second to intervene, and third for recall and setting aside. Now, my lord, your lordship will take the order. My lord, Wipro is on the screen.
I was just noticing your lordship knows the Birla facts as well as we do. Dates of orders, lordship.
Yes.
Now, my lord, if your lordship takes, my lord, the order. My lord, this is an order which was passed in an execution proceeding. Order is at page 56 of the application. The execution proceeding, my lord, terms of settlement, the terms of the decree was being satisfied. And my lord, now there is no proceeding, no list before your lordship by this order. Your lordship will see. The decree holder has filed the present execution proceeding for execution of the decree of 18th December 2017. Learned counsel appearing for the decree holder submits that though the parties have settled their dispute in terms of prayer in the tabular statement by entering into an agreement of 22nd July 2025, which is annexed with this application, this further submitted that before the agreement is entered into by the parties, the company has changed from Arch Realtors to Bhumaiya Realty Private Limited. Subsequently, Arch Realtors Private Limited is incorporated under the Companies Act and the company is Bhumaiya Realtors Private Limited. Considering the above, this court finds that the decree passed by this court on 18 December has been fully satisfied by entering into the agreement as well as by changing the name of the company. Thus, there remains nothing in the execution proceeding. Accordingly, ECOM 505 of 2025 is disposed of. So, no list lies before your lordship. Now, my lord, the present application is a recalling application. Essentially, is styled under section 151 of CPC. There is no other provision. Now, this kind of an application is not maintainable at the instance of a third party to the proceeding. These persons are asking to intervene by the fact that they are asking themselves to intervene. That means they are not party to the proceeding. So whether a third party can maintain a proceeding for recalling of a decree in a proceeding which has already been where there is no proceeding left. Lordship will kindly take, my lord, this judgment of Supreme Court, 2022, 19 SCC 806. 2022, 19 SCC 806.
You are appearing for the plaintiff.
I'm appearing for the Bellevue. Both appearing. They are claiming to. They want to. Appearing for the. They want to. Whether the current my lord has to now determine.
That's why I am.
Yes.
Court is in confusion.
Who is the current my lord has to determine? Whether one who originally held the decree or someone who came in as a third person and took away
as of now, my lord, various courts they have tried, and it is not this proceeding.
We will answer
proceeding. And I will show, my lord, it is this action of this particular Mr. Daga and Mr. Damani to intervene in other proceedings also. So this application, apart from all, is also an abuse of process of court.
See,
yes, my lord.
There are some clients in every state.
That's a different issue. No, that's a different.
It is both sides. It is a very hot client.
With the bar members.
That's for both sides. That is not restricted to any one side.
That's what I'm telling.
And same arguments are also being made every time.
Yes.
Yes, my lord. Your lordship will take my lord, lordship will take the first paragraph and just see what had happened here, my lord. Leave granted, the present civil appeal has been filed by the appellant against the impugned final judgment and order of 21st September 2021 passed by the High Court of Telangana in interlocutory application. The brief facts of this case necessary for disposal of the appeal are as follows. The present dispute relates to old Sai number in Shamskuda village, Rangareddy district, Telangana, forming part of number 252 list of mutkas in the preliminary decree dated 6th April 1959 by the erstwhile High Court of Andhra Pradesh. The underlying original suit was filed in 1953 by the City Civil Court, Hyderabad, by one Sultana Begum, the daughter of Nawab Mansur. The plaintiff was seeking partition of the properties of the Nawab The suit was ultimately transferred to the High Court, numbered as so-and-so. The suit, along with certain other applications, were disposed of by a preliminary come final decree dated so-and-so, passed by the learned judge of the High Court of Andhra Pradesh. The judgment recorded that the plaintiff withdraws the suit against defend numbers so-and-so. It also recorded that compromise was effected among some of the defendants. The litigation relating to this original suit subsequently entered a complicated phase wherein several defendants, different parallel proceedings take place. Suffice to say that even 60 years later, the issues remain the same. It is to say that the present appellant that they acquired a property, well, and I'm skipping that. Your Lordship will take para 5. On the above basis, the application, the appellant, an application was filed in CS so-and-so by the appellant herein along with the party not before us for passing a final decree in favor in respect of the property. A further prayer was made for direction to deliver physical possession of the said property. The learned single judge of the Andhra Pradesh High Court allowed the said application with a final decree dated 19 September 2013 as sought by the appellant and granted a declaration that they are absolute owners. The state of Andhra Pradesh challenged the order by so-and-so after formation of the state of Telangana on bifurcation of the state of Andhra Pradesh. State of Telangana filed an application condonation of delay in filing the appeal. Respondents IA, the appellant state that the delay in filing so-and-so is amounting to delay. By the order of 22nd December 2020, the division bench of the High Court dismissed. So, para 9. In the circumstances, after a lapse of nearly 7 years of the final decree being granted in favor of the appellant, the respondent herein filed 6 IAs before the Telangana High Court. The details of the applications are as follows. Your Lordship will find, my lord, the application leave to implead. Then, my lord, your Lordship will find with the impleadment was allowed on so-and-so date. And my lord, your Lordship will see, my lord, against the second last date, 5th May 2020, to recall the order of 19 September 2020 passed in the above mentioned application and to set aside and pass such order as deemed fit. So, my lord, impleadment and recalling of a decree will kindly come straight, my lord, to the legal issue which was decided here, my lord, para 27 onwards. In exercise of powers under section 151, it cannot be said that civil courts can exercise substantive jurisdiction to unsettle already decided issues. A court having jurisdiction over relevant subject matter has the power to decide and may come either to a right or a wrong conclusion. Even if a wrong conclusion is arrived at or an incorrect decree is passed by the jurisdictional court, the same is binding on the parties until it is set aside by an appellate court or through other remedies provided in law. Section 151 can only be applicable if there is no alternative remedy available in accordance with the existing provisions of law. Such inherent power cannot override statutory provisions or create remedies which are not contemplated under the code. Section 151 cannot be invoked as an alternative to filing of fresh suits, appeals, revisions, or reviews. A party cannot find solace in Section 151 to allege and rectify historic wrongs and bypass procedural safeguards inbuilt in CPC. The respondents in the present case had access to recourse under Section 96, which allows for appeals from an original decree. It must be remembered that the present matter which was being heard by the High Court exercising original jurisdiction, the High Court was in effect conducting a trial and a final decree passed by the High Court on 19 September 2013 was in effect a decree in the original suit. As such, there existed a right of appeal under Section 96 for the respondents. Though they were not parties to the suit, they could have filed an appeal with the leave of the court as an affected party. Well, then Section 96 is quoted. Then para 31. Section 96 to 100 deal with the procedure for filing appeals from original decrees. As a perusal of the above provision makes it clear that the provisions are silent about the category of persons who can prefer an appeal. But it is well settled legal position that a person who is affected by a judgment but is not party to the suit can prefer an appeal with the leave of court. The sine qua non for filing an appeal by a third party is that he must have been affected by reason of the judgment and decree which is sought to be impugned. In the light of the above, it can be safely concluded that an aggrieved party can prefer an appeal with the leave of the court. The High Court in the impugned judgment relied on the judgment of this court in Indian Bank for the Satyam Fibers, wherein this court acknowledges the possibility of maintaining a recalling application against a judgment if it is obtained by fraud on court. However, it went on to hold that in cases of fraud, the court may direct the affected party to file a separate suit for setting aside the decree obtained by fraud. The court held as follows. The judiciary in India also possesses inherent power, specifically under Section 151 CPC, to recall its judgment or order if it is obtained by fraud on court. It is in the case of fraud on a party to the suit or proceedings, the court may direct the affected party to file a separate suit for setting aside the decree obtained by fraud. The subsequent judgment of this court in Ram Prakash Agarwal versus Gopi Krishna further clarifies the law on the use of the power under 151 by the court in cases of fraud and holds as follows. Para 13 is quoted, my lord. Para 13 and 19 are important. Section 151 CPC is not a substantive provision that confers the right to any relief of any kind. It is a mere procedural provision which enables a party to the proceeding of a pending suit conducted in the manner that is consistent with justice and equity. The court can do justice between parties before it. Similarly, inherent powers cannot be used to reopen settled matters. The inherent power of the court must, to that extent, be regarded abrogated by legislature. A provision barring exercise of inherent power need not be expressed. It may be implied. It may even be implied. Inherent power cannot be used to restrain the execution of a decree at the instance of one who is not a party to the suit. Such power is absolutely essential for securing ends of justice and to overcome the failure of justice. The court under Section 151 may adopt any procedure to do justice unless the same is expressly prohibited. In view of the above, the law on this issue stands crystallized to the effect that the inherent power enshrined under 151 can be exercised only where no remedy has been provided for in any other provision of CPC. In the event the party has obtained a decree or an order by playing fraud on the court, or where the order has been passed by mistake of the court may be justified in rectifying such mistake, either by recalling the said order or by passing appropriate order. However, inherent power cannot be used in conflict of any existing provision, or in case the remedy has been provided by any other provision of CPC. Moreover, in the event that the fraud has been played upon a party, the same may not be a case where inherent power can be exercised. The High Court, relying upon the above judgments of this court, which recognizes the power to recall, seems to have lost sight on the restrictions imposed while exercising jurisdiction under 151, which were elaborately discussed by this court in the above mentioned judgment about exercising the power under Section 151 being only in circumstances where alternative remedies do not exist. Therefore, we are of the firm opinion that recalling a final decree in such circumstances cannot be countenanced under Section 151. The High Court erred in exercising its jurisdiction under 151 to hear and pass a detailed judgment recalling its final decree dated 19 September 2013 rather than directing respondents to pursue effective alternative remedies. Having said the above, we must clarify that we are not in any way doubting the proposition of law that fraud nullifies proceedings or that the court has a power. Here, there is no case of fraud. They have not pleaded any fraud. Here, there are cases that they are third party. They are seeking impleadment. No particulars of fraud, nothing has been pleaded. Their case, my lord, is simply stated here that they have to be impleaded, and my lord, that they are asking for setting aside of the order. That, my lord, we can't do under Section 151.
That's all.
No, my lord. Now, my lord, there is a third angle, which is the abuse of process.
Well, do I get to argue my application at all, or Mr. Mukherjee also only wants to, my lord?
Banerjee will get his chance, my lord. These matters are heard over dates.
No, my application. So, my lord, I've not been, my lord, yet.
Yes, my lord.
Been allowed to, my lord, even say anything on my application.
Original said writ application become a suit now.
Now, my lord, this is on the abuse of process. This is not the first time, or my lord, for the fifth time they are coming. This is multiple number of times they've tried to come and intervene and put a halt on proceedings, my lord, on the process that is being going on.
Yes.
So we'll see.
Hey, 345 matter আছে কি? 345 matter is there.
But should we come back tomorrow?
Parties. Other side is not there. If you come, then okay.
Yes, Malad.
Then
If they come, we can come back tomorrow. I'll take some time. Tomorrow. Malad, your lordship. Yeah. Oh, Malad, Mr. No, tomorrow is. Well, at the earliest opportunity. Tomorrow. I mean, no, क्या ना बोल ready? Malad will take Malad. A recent Malad, they tried to intervene. They filed a suit Malad trying to intervene in proceedings with regard to well, some of the subsidiary companies for operation of bank account of some subsidiary companies claiming that they are directors, these same persons. But on the basis, and the resolutions are also very similar. And it's the same personnel also. Your lordship will kindly take the
may I just correct you, Mr. Mukherjee? This was not a suit. This was a writ petition, disposed of writ petition, and application was made for intervention and recall.
The first paragraph only shows, Malad. There were writ petitions which were there. Malad, writ petition. The present intra-court appeals arise out of common order passed on 3 different applications filed by the present appellants. No, they were there. The writ petitions were filed by the petitioners wherein challenging an order whereby and whereunder bank accounts are frozen by Axis Bank. The learned single judge passed an order on 9th April 2025, passing directions for defreezing the accounts of the writ petitioners. The order was subject to deposit of an indemnity bond as per the bank norms and giving liberty to the writ petitioners for raising any other issues arising out of freezing of the accounts. The order of the writ court was not being implemented, giving rise to a contempt application. One application, CAN 1, was filed by Axis Bank seeking clarification of the order of 9th April 2025 as regards details of the signatories who may be allowed to operate the accounts upon defreezing. At this juncture, the present appellants filed CAN 2 seeking intervention in a disposed of writ petition and recall of the final order dated 9th April 2025. Malad, the present appellants, the same persons. Malad, your lordship will see, Malad, in the cost title, the appellant is named Krishna Damani and others. First grade. At the bottom of the IA and Maths and IA after that. So at this juncture, the present appellants filed applications CAN 2 seeking intervention in the disposed of writ petition and recall the final order of 9th April passed in the writ petition, identical to our case. The learned single judge passed an order on 19th May 2025 directing that the final order in the writ petition shall not be acted upon any of the parties by any of the parties for the time being. The order of 19th May 2025 was put to challenge by the writ petitioners in Mat so and so. In the appeal filed by the writ petitioner to the division bench, before the division bench, it was submitted that the applicants were not necessary parties to the writ petition. Several grounds were urged before the division bench, including the ground that the bank was required to approach the proper forum for appropriate order of injunction, if at all the bank believed the account was required to be frozen. Acting only on a complaint, the accounts could not have been frozen. It was urged that the account was frozen on the complaint of the erstwhile directors in view of the pending management dispute. Marking of the management dispute was subsequently reversed and the writ petitioner company was unmarked, and thereafter there was no management dispute. The bank was intimated regarding such demarking. It was also contended that the present applicants were no longer directors of the writ petitioner company. They were erstwhile directors of the writ petitioner company. Their removal was put to challenge under 241, 242. The same was dismissed by the NCLT and an appeal is pending before the NCLAT. Since currently the applicants are not directors in the writ petitioner company, the applicants have no locus standi to claim intervention in the writ proceeding. Here, my lord, Mr. Daga is no longer the honorary secretary. It was also urged by the writ petitioners before the division bench that the Axis Bank was acting in tandem. Then, para 10, the present applicants, appellants, however, contended before the coordinate bench that since an appeal was pending before the NCLAT, it cannot be said that there is no pending management dispute. Whereas similarly here, they cannot contend that since the suit is pending final adjudication, therefore, there's an issue as to who is in management, who is the honorary secretary. Same thing. Under these circumstances, at this stage, a permission to operate the accounts would be prejudicial to the interests of the company. The accounts, therefore, should continue to be frozen till pendency of the appeal before NCLAT. It was submitted that the accounts were initially frozen on the complaint made by the present applicant, and therefore they were necessary parties to the litigation. Well, your Lordship will take para 12. After giving a detailed consideration to the issue, the division bench allowed the appeal, set aside the order of 19th May 2025, and requested the learned single judge to take up all pending applications together as per their convenience. The division bench thought it proper that the learned single judge dispose of the recall application filed by the respondent of 5 to 7, similar application to your Lordship, and clarify the application of the Axis Bank first, and thereafter decide the content. The judgment of the division bench of the division bench dated 5th January was assailed before the Honorable Supreme Court and other analogous matters. The Supreme Court of India, by an order of 11th May, found no error in the judgment of the division bench. The apex court, however, clarified. The paragraph, it is needless to clarify that the single judge shall decide the application without being influenced in any manner by the observations made in para so and so, respectively in the impugned order. The learned single judge shall take up all applications pending before him for hearing and see to it that they are disposed of within a period of 3 months from today. Para 14, the pending application can do for intervention and recall of the order was thereafter decided by the learned single judge by an order of 23rd July 2026 passed in these writ petitions. The 3 orders are in the same terms and are subject matter of the present intercourt appeal. The recalling applications were dismissed. Mr. Kohli, the learned senior advocate appearing virtually on behalf of the appellants, submitted that the present proceeding was also rights inter partes, that is, between the writ petition and the applicants are pending in several other proceedings. The present dispute related to testamentary proceedings concerning the last will and testament of Srimati Priyamvada Devi Birla of the Birla family. It is submitted that the removal of the present applicants as directors is pending before the appeal court in NCLAT. The submissions regarding initial freezing of the accounts in question at the instance of the applicants is also reiterated in the present proceedings. In the event the accounts are made operative, the same would have a far-reaching and wide ramifications. Now, my lord, I skip now to the operative portion of the appeal order. Para 29. This is the appeal from the rejection of the recalling. Para 29. We considered the submissions. We find that the learned single judge in the impugned order held the applicants could not make out any case for intervention. The prayer for recall of the order could be considered only if the applicants' interventions were allowed. In the instant case, the interventions were not allowed. Therefore, there was no scope for the learned single judge to go into the merits of the matter considering the prayer for recall of the order. Under the circumstances, we made it clear to the learned advocates representing the parties that this court will confine its consideration to the issue of intervention which was decided by the learned single. We find that the impugned order in the present appeal was passed on applications filed in the writ proceeding with the present appellants. The coordinate bench, by a judgment of 5th January 2026, passed in Matt so-and-so and analogous cases, had also directed disposal of the application. Such direction was also affirmed by the Honorable Supreme Court, Apex Court, by its order of 11th May, which was quoted previously. Para 31. The present appellants were applicants before the writ court and parties to the order dated 23rd July 2026. They were not strangers to the order of 23rd July 2026. The impugned order dated 23rd July 2026 is passed by the learned single judge in the present appellant's application. The said judgment in the case of H. Anjappa supra relied upon lays down the law governing grant of leave to appeal, which declaration is binding on this court. In the present case, it cannot be said that the appellants were not party to the order of 23rd July passed by the learned single judge. We therefore find no force in the submission of Mr. Bachawat with regard to the para 33. This is whether they could leave to file to appeal or not. That the maintainability of the appeal was held okay, but after that. The above noted submissions advanced by the learned senior counsels for the appellant in substance raise mere apprehension. no tangible right was demonstrated to show that the applicants are proper or necessary parties. The plea regarding various disputes in the background of present application also would not justify filing an application for intervention in a disposed of writ proceeding, much less recall of the final order dated 9th April 2025 passed in the writ proceeding. Another issue with regard to maintainability of the application for intervention also arises since the applications for intervention was taken out in a disposed of writ proceeding when the court was no longer in season of the matter, identical to the issue here. In this connection, we refer to the decision of the Honorable Supreme Court of India in Orissa Administrative Tribunal versus Union of India, reported in 2023, 18 SEC, page 1. Para 109 is quoted. Now I'll just read it out. The doctrine of functus officio exists to provide a clear point where an adjudicative process ends and to bring quietus to the dispute. Without it, decision-making bodies such as courts could endlessly revisit their decisions. With a definitive endpoint to a case before a court or a quasi-judicial authority, party is free to seek judicial review of referendum appeal. Alternatively, their rights are determined with finality. Similar considerations do not apply to decisions by the state which are having regard to the above consideration and the judgment of the Honorable Supreme Court of India in Orissa Administrative Tribunal Bar Association, SUPRA, we find no scope for the appellant to file an application seeking intervention in a disposed of writ petition. We therefore find no reason to interfere with the ensuing order dated 23rd July 2026, rejecting the application for intervention. Before parting?
Yes. Although both are not there.
My lord. Should I come back tomorrow? I'll come back tomorrow.
Which matter? Chain matter, your. Okay. Agreement. You are the party to the agreement.
He shouldn't have parted, Mullah. He shouldn't have parted.
He has now.
Knowing this entire facts, he shouldn't have parted.
There is no facts not to
No, yes, that Mullah.
Facts have been created.
The company cannot enter into any transaction. They will accept an order of exchange, the defect from any portal. But today, I have never paid the money, and because of this quarrel between who should be controlling the trust, I am calling the cost. So, but there is extreme urgency.
No, tomorrow your lordship will take it. Tomorrow.
Tomorrow.
Well, at 3 o'clock we can come back.
The 3 o'clock matter possibly not.
It is your matter.
He's arranging, Mullah. His matter not before this. Mullah, let them finish tomorrow, Mullah. We'll come back, Mullah, the next week.
Okay. Then counsel for the respondent in GA Com 1 of 2026 argued the matter at length with regard to the maintainability of the application filed by the petitioners applicants. But due to paucity of time, hearing could not be completed. Let the matter appear tomorrow at 3 p.m. देखेंगे.
At 3 p.m. tomorrow.
Wait.
This is my petition, but I had concluded the submissions minute on this.
Yes. Huh?
Resolution, Lordship, not to it. All I was saying, Lordship, I am aware of the facts of this case. I have spoken to the concerned officers. I have impressed upon them to consider his request. Lordship can keep it after some time. We can again come back with instructions if it can be.
See. How soon you will take instruction?
Lordship, at least 4 weeks. Because there's a bureaucratic procedure, Lordship.
I was only hoping that the change is actually some change. And there is a change of fate of my client who has been suffering from.
Several matters have come to end due to change.
Yes.
In my court.
So, I hope the actual change of guard, there is actually a change in the heart.
Yesterday, the officers had come. The positive sign from
Yes,
their side
see,
that they will consider.
see, you satisfy the officers once they have been chosen, whatever it can be. Though the matter is specifically today as 3:45 p.m., but the learned counsel for the respondents prays for time to take instructions. Accordingly, case is adjourned. Let the matter appear on, give the date 21st September, 3:45.
But only one sentence possibly would help him to get. But would your lordship kindly put in a line that pendency of the writ petition will not prevent.
It
the
is made clear that in the meantime, if the parties
pendency would not
pendency
prevent
of the pendency, it is made clear that pendency of the present writ application will not prevent the parties to settle the dispute outside of the court. To settle the dispute outside of the court, or the respondents may consider the request of
Yes.
the petitioner.
I'm great.
ठीक है? Or to consider the request of the petitioner.
This line may do wonders. I'm grateful.
You persons, I have received the report from the department. You persons are not, even after receipt of the communication from the department, you are not going to the department for yes, it is, a report is there. Report is here. Huh? Now you mentioned the matter, but you are not going to the department. On receipt of the communication, plaintiff is directed to correct the cost title of the defendant within a week. According the last for correction of the cost title is directed on 6th of August, but you are not went. Okay, you একটা কাজ করুন। The counsel for the, you are a plaintiff. Counsel for the plaintiff prays for a day's time to take appropriate steps for amendment in the cost title of the plaintiff. Accordingly, the plaintiff is directed to comply with the order dated 23rd July 2026. Within a week from date, list the matter. After a week, the record be sent to the department. Today, which for the other side? I have no problem. If the other side is there, come. It is there, but nobody is there. What can be done? Let it be remain in the list. It will be remain in the tomorrow. She is telling that 27th, 28th. Where is order? Till 20. Today, what is the date? 18. Yes, tomorrow. Officially. Okay, we'll see. Which one? Appellate side. Come tomorrow morning. Come tomorrow morning.